On behalf of Learned Senior Counsel, Mr. M.Z. Ahmed, I beg to mention item number 10 and 13. These out of the company matter item 10 and 13.
Have you taken the consent?
Yes, Madam. Yes, sir.
Item number 10 and 13 to be listed after 4 weeks. The request of the learning councils appearing on behalf of the respondent who want. Beleg law, no?
Dear list item number 1. Part 1 and 2.
On the last occasion, I was allowed to obtain some instructions. Some instructions have been received, Lordship, and I would like to submit on those. Lordship, your Lordship peruses page 36 of WPC 1974 of 2020.
Page
36.
30?
6.
Yes.
Lordship, in the middle portion, Lordship will find that it's written as said to contain. Said to contain is written in the middle portion, Lordship.
Yes.
Lordship, on page 37, the point number 3 it reads as this inland way bill is issued subject to the conditions and liabilities as specified in the Railways Act 1989. So the Railways Act has been invoked, Lordship, and
Said to contain?
said to contain means, Lordship, in the Railway Act, section 65 deals with that, Lordship. Section 65 of the Railways Act deals with that, Lordship. When something is written on the railway receipt, Lordship, that the consignor will be liable for the declaration made in the forwarding note or the stuffing report, Lordship, then the railway authority or the control authorities won't supervise that. Lordship. That is what is being instructed in the Lordship. If your Lordship peruses section 65 once of the Railways Act.
Yes.
The second 65(2), Lordship.
Hmm.
The railway receipt shall be prima facie evidence of the weight and the number of packages stated therein, provided that in the case of a consignment in wagon load or train load and the weight or the number of packages is not checked by a railway servant authorized in this behalf, and a statement to that effect is recorded in such railway receipt by him, the burden of proving the weight, or as the case may be, the number of packages stated therein shall lie on the consignor, the consignee, or the endorsed. So, Lordship, herein the consignor, basing upon this stuffing report and the forwarding note of the consignor, this railway, this Concord bill was made, Lordship, and herein, Lordship, paragraph 4 also specifies that, Lordship, that the consignor will be liable for the declaration made. Lordship. I'm reading paragraph 4 of page 37. Lordship. The consignor must accept responsibility for all particulars furnished in respect of cargo tendered by him for stuffing in container and carriage by Concord. The consignor is deemed to have indemnified Concord against any damage or loss suffered by it by reason of incorrect or incomplete particulars furnished by him in regard to the cargo. The consignor was responsible, Lordship, and the facts are like this, Lordship. On 13/11/2014, consignment was booked from Rourkela to Amingaon, Lordship, and it reached Amingaon on 14/11/2014. And subsequently, Lordship, actually what had happened, there were 80 containers in that rake, Lordship, in total. And out of those, 41 containers were,
Mr. Sharma,
Lordship,
this is a case of misdescription.
Lordship.
Misdescription of the goods.
Lordship.
Meaning thereby, if somebody, because if a particular type of goods is there, the charge will be different. And if a particular type of other goods is there, the charge would be different.
Yes, Lordship.
That's the reason why.
Yes, Lordship. Lordship, that's
Now-
what I'm coming to, Lordship.
Now you come to that. Before that, let me explain. 65 says as only as regards weight and the packages.
Lordship.
No, that is it. 65 only says about weight and packages. Here, the amount which you have have imposed upon him, upon the petitioner, is on the basis of a policy of the railways to that effect that if there is any mistake committed by them, then in that regard, you are going to impose, the railway is going to impose upon you. You are the person. You are the transport. Now, this undertaking, the terms and conditions mentioned therein at serial number 4,
Lordship.
is a liability which the consignor would be liable if there is a misdescription. Is there a misdescription in this case of the consignor, in this case, for the purpose of the petition?
Actually, Lordship, this circular, Lordship, will find it at
Circular, I have looked into it.
56, Lordship.
There's nothing else to see in the circular.
Lordship will then have to peruse paragraph 2.3 of the circular, Lordship.
Yes, where is it? 2.3. 2.6.
Page 55, Lordship will find that. 2.3,
Page 55, yes.
when a notified commodity is loaded in more than 30 containers of a container train, either as a single commodity or mixed with other commodity, including other than notified commodity, haulage charges for such containers will be levied as per container class rate. For the containers containing single notified commodity, haulage charges will be levied as per container class rate of that commodity, and for the container loaded with 2 or more than 2 commodities, haulage charges will be levied on the basis of highest container class rate of the commodities which the container contains. The paragraph 2.4 is also relevant, Lordship. If 30 or less than 30 containers TEUs in a rack are loaded with any of the notified commodity groups, either as a single commodity or mixed with other commodity, including other than notified commodity, haulage charges for such container will be levied as per rates prescribed by rate circular number 32 of 2010 and as amended from time to time. However, the containers loaded with other than notified commodities or are empty, haulage charges for such containers will continue to be levied as per rates prescribed by rate circular number 32 of 2010 and as amended from time to time. Lordship, what had happened in this case was that they declared that 30 containers contain sponge.
Who
I-
declared?
The consignor, Lordship. Here 2 consignors are there. One is Reliable Sponge and the other is Bhavani Industries, Lordship.
Then
The consignor for the petitioner was Reliable Sponge, Lordship. They had declared that in 30 containers there is this commodity, Lordship, iron, billets or ingots, Lordship, and the rest it would be 50 containers, Lordship, that contains sponge iron. Now, sponge iron is not a notified commodity, but iron of or billets, ingots or billets, it's a notified commodity, Lordship. Now, 2.3 says that, Lordship, if 30 containers or more,
where is that statement you are making in your affidavit?
Lordship, is there.
The consignor had put so many containers.
Lordship. Paragraph 8 in this
Of which affidavit?
of the old case, Lordship, 2015
Earlier case.
case, Lordship.
affidavit filed by respond numbers 2, 3, and 4.
Yes, Lordship.
Huh?
Yes,
Yes, where is it?
paragraph 8, Lordship.
8. Yes.
The deponent begs to state that the IWB's
Para 8 that with respect to paragraph 15, 16, 17, 18.
and 19 of the
19.
petition under reply, your deponent begs to state that the IWBs were issued on the basis of document furnished by the consignor, and in this case, the respondent number 5 had submitted a forwarding note containing 41 sponge irons. It is pertinent to mention here that the stuffing report furnished by the consignor shows 23 ingots, 17 sponge iron, and 1 TMT structure, whereas there is one container so and so for which 2 stuffing sheets were given, with one stating the cargo as billet sponge iron and other as ingot. On bare perusal of stuffing reported so and so and annexure G, it becomes very clear that the respondent number 5 baffled the deponent and got the IWBs issued illegally, which are not considered consistent with the documents.
Issued,
That was the bill
issued
that
suitably.
IWB's Lordship.
No, no.
Inland way bills
Got the inland way bill issued
issued illegally.
illegally, suitably.
Our Lordship.
In your case, it is illegally. But in my case, it is written out here suitably.
Sorry, Lordship.
Huh?
There might be some mistake, Lordship.
Mistake. And mistake you are finding it out in 2023 after what you have done in 2014. So
Lordship, that was wrongly done
by
the consignor, Lordship.
so take it from the consignor. Why you are disturbing the petitioner? Who is the consignee?
Lordship, actually what had happened here in Lordship,
Huh?
the consignor Reliable Sponge, who is the consignor for the petitioner, approached the Odisha High Court, Lordship. That order is at page 69 of the new case, Lordship.
Yes.
Lordship, I am reading.
Considering the submissions of the learner appearing on behalf, this court disposes of the miscarriage by modifying the order to the extent of directing the opposite party to accept the individual bank guarantees as against the penalty in respect of differential freight weight filed by the individual consignee.
I'm sorry, Lordship. Actually, what had happened earlier, he approached on the consignor approached the Odisha High Court, Lordship, and then there was an order wherein the consignor were required to pay the differential price. Lordship. Subsequently, a modification application was filed by the consignor, and then this order came to us.
What is
The
that order?
earlier order, Lordship, will find at page 65, Lordship.
69.
65.
Yes.
Miss case number 1620 of 2015.
Hmm.
As an interim measure, it is directed that subject to petitioners depositing the differential price charges as indicated under Annexure 3 and furnishing a bank guarantee as against the penalty as indicated therein within a period of 2 weeks, the cargo of the petitioner detained due to alleged misdeclaration be released in favor of the consignee. So the consignor was required to pay the differential price at that point of time. Subsequently, he again approached that court, and on 3/3/2015, that order was modified, Lordship,
That he will give the bank guarantee.
that the consignees were furnished differential price, bank guarantee upon differential price individually, Lordship.
Consignee.
Yes, Lord.
Where the consignees were parties there.
No.
How can this order
That
be
was
made
the case
effective
filed-
against the petitioner?
Yes, Lordship. That was the case filed by the consignor therein, Lordship.
Now have you released the goods?
No, Lordship. Subsequently, what had happened in the old case, Lordship, Lordship will find that rule was issued on 4/4/2016, Lordship.
One.
4/4/2016, Lordship. In that order, Lordship, they were given liberty, Lordship, to secure release of their consignments, Lordship.
One.
It's 4/4/2016.
In the interim, the petitioner, if so advised, may also furnish bank guarantees and secure release of the iron seized by the container. Then,
Lordship, but then this order of the Orissa High Court is still,
that is a
Subsisting
different
law.
thing. But madam, have you got your goods released?
No.
Then, how can you impose it upon the consignee? Show me that.
Lordship,
You take whatever action you want to take against the consignee, you take it. But we are not concerned with regard that. If there is a misdescription, but how can you penalize?
because Lordship, that
Show
circular
me
comes
that
in
the
law.
consignor, because of the fault of the consignor, the consignee would be liable. Show me that.
Lordship, the railway Act, section 65 itself says that.
65 says what? 65 says about weights and packages. We are not concerned with the weights and
It
packages.
includes that, Lordship.
65 does not say anything to that effect.
The number of packages stated therein, Lordship.
Yes, package and goods and the weight. Because what happens, there a railway receipt is, in the railway receipt down below it is given that booked out there on, what is that? What is the term used, Mr. R.K. Dev Chaudhary? What is the term used in the railway? You must not be aware, being a central government council. The railways will know. Yes, Mr. Amit Goel, what is the term used? Huh? Said to contain, no, said to contain, no, there's another thing. There's a receipt, and that receipt down below, it is not only there, it is mentioned that they have not measured or anything to that effect. In the railway receipt, it is down below, it is printed out.
But railway receipt is, my lord, negotiable instrument.
Uh.
But then it's shifted, it can be transferred to him.
Herein also paragraph 4, Lordship, will kindly see.
Of
Therein
what?
Of the particulars furnished by the consignor, he is responsible for that.
Absolutely, take it up with the consignor.
Yes, Lordship,
But why are you detaining this goods from 2015?
but the consignor has not appeared in this case, Lordship.
Very well.
He has not appeared.
Then why are you not taking? He has not given
Not
the bank
only-
guarantee.
Not only the goods of the consignee, Lordship, the goods of other consignees were petitioner, Lordship. Other consignees were also detained due to that misdeclaration, Lordship. Subsequently, they furnished bank guarantee and got their goods released, Lordship. But in case of the
Bank guarantees for what?
for the misdeclaration, Lordship.
Then what is going to
Differential
happen?
type, Lordship.
Bank guarantee is temporary.
Yes, Lordship.
It's a temporary measure.
But it is being renewed every year. I have been
Understood. Till when?
till the case is decided by the Orissa High Court, Lordship, because that's pending before the court. And both the consignors, Mahavir Pero, Bhavani Company and the Reliable Phones have filed their cases there in law. And it's pending there.
So in Orissa High Court, that issue is pending.
Yes, Lord. And as per my instruction, Lordship, we have earlier contacted the consignor only, Lordship, not the consignor, Lordship. In the first occasion, when the misdeclaration was detected, Lordship, we had written to the consignor only, Lordship, and after that they kept silent, Lordship, and then they approached the Orissa High Court. Subsequently, what they did, Lordship, that the consignees were made responsible for that furnishing that bank guarantee for the differential price, Lordship, by that order. So that was the thing played by the consignor.
That was the gameplay. That was the gameplay. We said we are not bound by it.
No. If there is a responsibility of the consignor to pay,
Lordship,
and if the consignor does not pay,
Lordship.
then what is your recourse?
Lordship, there is no such rule which we can.
No, there has to be a recourse. How do you take it? When he says that he will indemnify, the consignor will indemnify, not the consignee. So there is no relation, there is no privity of a contract between you and the consignee. You have no contract. Your contract is with the consignor. So if the consignor does not pay, can you penalize the consignee? and hold the goods.
Because of this order, Lordship, if your Lordship.
No,
directs,
no,
then we
that
can
order
release.
cannot be the reason why. That is an interim order that would not get.
Until and
But
unless.
this
the
court is
different-
finally taking it up.
That until and unless the bank guarantee in respect of that differential price is paid, Lordship,
No, why will they pay?
that we are not saying, Lordship, that they needs to pay that. But the consignor needs to pay it, Lordship. Until and unless that is released, Lordship, that differential price, Lordship, we are not in a position to release those goods, Lordship.
But can you hold the lien on those goods? As per your
It's
terms of
lying
the
there
contract,
only, Lordship.
no.
I think
you have to show something that you can hold the lien on those goods till the amount is paid by the consignor. Or keeps you indemnified.
we also want those containers to be released, because the containers are depreciating, Lordship, and we have filed an IA to that effect, Lordship, but it's pending.
Understood, but Mr. Sharma, can you tell me one thing? Can you, as per the terms of your agreement, wait or contract with the consignor, hold the lien on those goods? If you can't, then can you hold the goods? It will have a serious consequences. What you are saying, if we allow such things to happen, then the transporter can say that, okay, if you don't pay me this amount, I'm not going to give it to you.
In this case, Lordship, since rule was already issued and liberty was given to the petitioner to seek release of his goods, Lordship,
For that, you may say that there has been already a, there has been the petitioner may not be entitled to damages on account of mitigation. That's a different aspect. We are not on that. We are only asking, I'm only asking you as to whether you have a right to hold lien on those goods on non-payment. If you don't have, matter ends there.
otherwise the Railway Act is also silent on that.
And indemnification is not given or there is a law, you can very well take it up with the consignor. But how are you affecting the consignee?
So, in this case also, Lordship, the consignor was a party, Lordship.
Understood. The consignor, obviously, the consignor has been made a party. It is okay. The consignor has not appeared. For that, this court can very well make an observation that against the consignor, that he has done all these things, he has not, and as such, he is responsible. Very well.
So,
This
Lordship,
can
we
make.
are ready to release those goods, Lordship.
But can you hold the lien upon those goods so far as the petitioners are concerned? If you can't, you have to release it
Yes, Lordship. We are also seeking release of.
and then take up whatever action is required against the consignor. You can file civil suit, you can file arbitration, whatever you have with them. That is a recourse which is available. Or even say out there in the Orissa High Court that look at the Guwahati High Court has released this, we have this amount to be paid. And as such dismiss the petition. You can say all these things. But can you hold the lien on those goods? You can't. The very serious thing which you have done. You have taken the goods as a ransom.
It's a difficult situation, Lordship, in
Huh?
this case.
Peculiar.
Lordship, yes, Lordship.
There's no peculiarity. It's a simple contract case. As to can you hold the lien?
That is not there, but Lordship, since the goods were in our custody all along en route, Lordship, and there was a misdeclaration detected, and Reliable Sponge and Bhavani traders, they have also,
Let us assume they have done all wrong things.
Lordship,
But can you impose upon the petition with the consignment? Because the consignment,
we have
it doesn't
nothing
say
else,
anything.
Lordship.
It is purely a contract between you and the consignor, where the consignee is no longer a party. There is no declaration or misdeclaration made by the consignee.
Lordship, in the receipt itself, Lordship, the name of the consignee appears, Lordship.
Understood.
And, the consignor alone saying that the consignor alone is liable for this lordship won't suffice lordship, because that is still in private limited knew about the consignment being carried from
No,
Rourkela
they will be only concerned with their own consignment.
Lord.
Their own consignment says Ferra Alloys
lordship.
or
In
MS Ignore.
lordship.
Their consignment is very clear on that. They are only concerned. A particular consignor may send hundreds of goods. There is only one party out here. We are concerned with the petitioner. The petitioner has got this particular, there is a no misdescription to her goods. The consignee. And it says the consignee has no problem with that. Can the consignee say to the consigner, look here, you can't send any misdescription? No.
But they entrusted at that point of time upon the consignor lordship for transportation of the goods. They entrusted the consignor for transportation of the goods at that point of time. lordship.
Absolutely.
And for that lordship, some liability is to be,
Upon them.
yes, lordship,
How?
because they entrusted the consignor lordship and they made the misdeclaration.
Who?
lordship. The consignor lordship.
Consignor made. I'm
Yes.
saying that is why the consignor may have made it. In respect of some other goods which the petitioner is no longer related. How can you impose upon the petitioner for that?
Lordship may kindly peruse section 74 once.
Section
74
of,
of the Railways Act law.
okay.
The property in the consignment covered by a railway receipt shall pass to the consignee or the endorsee as the case may be on the delivery of such railway receipt to him, and he shall have all the rights and liabilities of the consignee. Herein, lordship, the railway receipt was to be produced at the point of time when delivery was to be taken, lordship, but then this declaration got detected on 15/11/2014, lordship, and due to that, lordship, the goods were withheld, lordship. 83 and release in one, lordship, section 83.
Mr. Sharma, tell me what is your contract with the consignor?
That is what the section 83 says, lordship, the lien, lordship, lien part, lordship was asking, lordship. It's being there, substantiated there, lordship.
I'm therefore asking you, what is your contract with the consignor? Are you the railway authority?
No,
Are you issuing a railway receipt?
no, but the railway
This-
is being followed.
Therefore, I was asking you whether there will be a liability upon the consignee for the fault of the consignor is a subject matter of a contract between you, consignor, as well as so and so. You are dragging in the railways. Your contract is with the railways, where the consignor is not a party, neither the consignee is a party. You have a contract with the railway. You have taken a particular rack from the railway that you will be moving these containers. So a receipt has been issued to you, or a separate contract will be there between you and the railways. We are not concerned. But have you stated out there that the principles of 74 will be applicable
The
out there?
whole of the railway act, lordship. Whole of the railway act will
Where?
apply. Page 37 of the new brief petition, lordship.
Yes.
The third paragraph, lordship, the
Ah.
inland way bill is issued subject to conditions and liabilities as specified in the Railway Act 1989.
Now this makes sense.
There, lord.
Yes, madam. Tell me here.
Yes, okay.
You see, he is drawing the reference to section 74 of the
Railways Act.
and says that the inward inland way bill
Yes.
is issued subject to the conditions and liabilities as specified in the Railways Act.
Right.
So he says that the liability of the consignor shifts upon you being the consignee.
Shall pass as the property, shall pass to the consignee or endorsement, and the same may be by virtue of the, yes, Lordship. It would have shifted upon you if there had been a misdeclaration.
Huh?
If there had been a misdeclaration.
No, there has been a misdeclaration by the consignor. There's no quarrel
Not
there.
in my case.
Not in your case, but otherwise it is.
In that event, that railway circular has to go.
Huh?
In that event, the railway circular by which I have been imposed a penalty for no fault of mine.
No, your penalty is not on the basis of the railway circular. The penalty is upon the consignor because of the railway circular.
Because of the railway circular.
And not on the penalty is not even upon the consignor. The penalty is upon
Him.
him.
Correct.
And he has thereupon imposed the penalty, or for the matter, passed on the penalty to the consignor.
Consignor, right.
And in eventually, by virtue of 74, you are hit.
Yes, Lordship.
So how is the Railway Act bad? Railway Circular bad? Railway Circular is very simple. That you see, if you make a misdeclaration, person is him. If he makes a misdeclaration, he is making a misdeclaration to the railways on the basis of a misdeclaration being made by the consignor. And for which the consignor is liable, and accordingly, by virtue of 74, you are.
I become liable because of that. Even though, Lordship, I mean, that becomes very illogical, the entire thing.
Why?
Even though, because I am not responsible for anything. Now, by bringing section 34 of the Railways Act,
74.
74, sorry, you are making me liable for some foreign offense, which I have not.
You are not. You become liable because of the consignor. You are not. You have not committed anything, but the consignor has done it. And the consignor's rights and liabilities in view of the railway receipt stands transferred to you.
But can the consignor of, in my case, for this particular goods, which he has transported on my behalf, can the consignor
Then the
Also-
consignor has not transported on your behalf. The consignor has transported it to it to be given to you.
to be given to me, right? But what in my case, consignor has not committed any illegal.
How can you say you are the consignor is not before this court? Consignor is before in Odisha.
Consignor is before it. But from the records, Lordship, it's clear. From the records, as far as my goods are concerned.
No, your goods is not the question. The fact that there is a particular statement being made in the affidavit
Yes,
saying that the consignor has made misdeclaration, which you can't verify.
Lordship, we'll look at page 94 also. There's a report
Of which writ petition?
the new one.
New one. Okay.
Okay.
Yes.
Yes. We conducted a physical verification, arrived at this authorized agent on the party of security and found that 63 of this with billets, while others were spent was sponge iron. Among the 33 was declared as ingots and billets, and the rest declared as this. The joint survey opened with this, and then he gives the joint survey. Then he gives the report. So on this, my part is very clear, Lordship. Concord is there. That's a transporter. Clearing agent, forwarding agent is there, and security is also there. Lordship, even Concord.
No, in fact, this is very aspect can be seen from his affidavit. Finally, see paragraph 8 of his affidavit, filed into the 2015 matter.
Yes.
Paragraph 8. This is what he is also saying. That
Yes.
this has happened and there has been a misdeclaration being made by Reliance Sponge.
Yes.
And because of the misdeclaration, this has resulted in this by virtue of 2.5. You
Correct.
can very well, if you have been penalized because of that, you can then again take it up with the consignor, whatever may be. But the fact that this amount has to be cleared or done to that effect, the liability shifts
the-
in view of 74.
But Indian weighbridge, Lordship, the inland weighbridge. There's a different. For me, I have different sets of paper. Every consignee will have their own inland weighbridge. It's not a club. It's not club. So my will be different. So if it had been clubbed, Lordship 74 would have come in and I would have been responsible. But as far as my bill is concerned, it's not clubbed with the rest. It's an individual bill for me. Just for,
Madam, I understand everything.
yes.
There's no fault on your part.
So,
He's also saying that there is no fault on the part of the consignee. But the fault is of the consigner.
right, Lordship.
And if the consigner has made any misdeclaration, there is a liability upon him.
Yes.
And that liability shifts to you because of 74.
But Lordship, my receipt, the individual receipt.
Absolutely. So you have to, your only way recourse is take it up with the consigner that we had to pay you, return us the money. That's all. There's no other way out.
Lordship, since my receipt is different, when I produce my receipt, how I am only responsible for what that receipt contains.
Because of 74.
Because of 74, I am only responsible for what that receipt contains, not for any other. But 74 talks about individual receipt, not about the entire rate.
No, madam. I think I'm not been able. The railway receipt which has been issued is between the railways and him.
Right.
Absolutely between both of them. Now, he has undertaken to the railways to pay the railways
Right.
if there is a misdeclaration. Now, what he does, he takes the goods from the consigner and another person. And there is a misdeclaration by that consigner to him.
Right.
And there is an indemnifying clause by the consigner in that terms and conditions.
Yes. Right.
Now, as per that, the consigner would be liable because of the misdeclaration, and that liability which the railway has imposed upon him has to be indemnified by the consigners. Now, a part of that falls in you
Yes.
because of the consigner, not because of your fault.
Yes.
And that is because of Section 74. That is the problem. The only way out is to challenge 74.
Then I have to file another writ challenging it.
You know, otherwise there is no problem with the other thing. Only 74 is the problem. And not only, it may not be 74, but clause 3 of that inland wave, where the problem arises, where the Railway Act has been brought within it.
Within possession. But what about the other clause, Lordship, the circular clause, where the entire railways, the circular which I have impugned, actually, Lordship will find, where the entire rate is imposed a liability for the misdeclaration.
That is
of one.
between him and him. You are nowhere. You are nowhere in the
But
scene.
consequent of that, I am being
Absolutely,
penalized
because of the consigners.
because of consigners. So I have a right to challenge that.
You have a right to challenge that, but how are you affected otherwise?
I am affected.
Only because of the fact that the entire wreck has been done because he has the liability.
Yes.
You are not the third, you are the fourth person who is affected.
Yes, Lordship. But by consequence of this, Lordship, it comes to me.
How is it wrong? It is absolutely fair on the part of the railways to say that look here, if there is a mistake, we are giving you this particular, these are the various rates on which it is there. If you give a misdescription on the goods, then you will be liable for 3 times.
No,
haulage
Lordship,
charge.
but here,
That is between the railways and him.
but here railway is imposing such, if this read with section 74 again, railway is making such a condition even where I am not responsible, I'll be liable to pay.
Railway is not imposing upon you. Railway is imposing upon him.
Indirectly, it comes to me.
Yes, it may be. In fact, it may indirectly also affect the customers to whom you are going to sell. and even to and those ignots being used out there for the buildings, where the buildings are constructed and a house is being taken by me, I may be affected.
But would it be fair?
Then I
Lord?
challenge that circular on the basis thereof.
But would that be fair?
Absolutely. What is wrong?
Absolutely.
They are saying that their only basic contention is that if you make a misdeclaration in your goods, you'll be liable to pay for the entire. That is between him and him. And he says, no, I am not going to make. This is my description. And it is found that there is a misdescription, so the railway imposes upon them. So look here. And it is between him and him. How are you affected?
Because I am getting receiving the brunt of it.
Are you not fighting the cause of the consignor now?
I am not fighting the cause of the country.
You are fighting because the imposition upon you the liability is
Yes.
because of the fault of the consignor.
Exactly.
So if I say that okay, you are liable or you can be taken, you can take the goods, then the consignor says that why should I bother to make the payment? I'll change my name. Instead of this, I'll put another name.
So what the consignor has done, consignor has shelved his responsibility, just passed it on. And to me.
So you take it up with the consignor that look here, why have you done all these things? Because of you, I have been put into all the problems. If clause 3 was not there, I was in your favor. That clause 3 makes the whole of a difference.
Yes, clause 3 creates a problem.
I didn't disturb you in the morning today. Till I saw clause.
He, like Lordship, he has been digging things all the time. Right from 2014, he digs up and he comes in piecemeal, Lordship.
Huh?
He doesn't come at all at once. He comes in piecemeal. First of all, he
that
found
Mr. Sharma keeps on doing.
at first, Lordship, he came up with the second circular. When we said the first circular has become it's not.
I'll give you time, madam.
Lordship.
You have a look out there. If you can just wriggle out from this problem.
Yes,
with
Lordship, a week's time.
have a look out there. But the only way out which I see now is this. Okay, list the matter again. On today is what? 20,
On Thursday, Lordship, where we reopened
29.
when Thursday.
Okay, list the matter again on 7th for further consideration.
He's very dangerous. I'm
Huh?
really scared of him, actually.
Now, I won't allow furthermore to enhance his argument. You just satisfy me on clause 3.
Yes, 74.
And number 3.
Here, the original petitioner,
Yes.
the private respondent are the legal heirs of the original petitioner's brother.
Hmm.
Now, sometime in 1980, there was a family settlement between the brothers and the other family, based on which the properties were divided, but this was not reduced to writing. It was already decided. The brother passed away in 1986. Sometime in 2004, a family settlement was drawn up between the petitioner when he was alive and the private respondent. This is an unregistered family settlement. Pursuant to this, there was also an affidavit which was sworn, which confirms the family settlement. Now, based on the family settlement and the affidavit, certain properties went to the private respondent, certain properties came to me. The private respondents, on the strength of this affidavit and the settlement, get their properties mutated. And I don't object. There is no notice also issued to me. That happens behind my back. I never objected. Subsequently, I moved for mutation. When I move for mutation, they file an objection. The mutation application is heard. The mutation order is granted. They come in appeal before the Board of Revenue under 147, along with the delay condonation application. And without issuing notice on the delay condonation application, if my lord straight away comes to page 60,
They just stay.
without, there is no, it's not a speaking order. Appeal admit, stay grant.
No. The order will be like this. The
Heard.
appeal has been admitted and the limitation point is kept open.
No, madam, this is a step further. Heard, admit, issue notices, impugn order be stayed, fixed for one.
He exercised 151.
I have come on.
Then
So therefore, all that I am saying is either the matter can be sent back and let it be decided in a time bound manner, or my lord will decide. Whichever.
what is the you are challenging only that order.
I'm only telling you.
Why did we stay thereafter?
Yes, there has been a thing.
My goodness, it is the 2011 matter.
13.
13.
It can either go back and it can be decided to be in 6 months.
So all this time there has been a stay unnecessarily.
There has been a thing. At 14 is the family settlement.
The family settlement has been given in your name.
Family settlement.
No. The order being passed by the deputy commissioner
Yes.
is in your favor,
Is in my
where the mutation has been
Granted.
granted. Against that, they have filed an
they
appeal.
filed an appeal.
So when they file an appeal, there is a stay and you have come before this court. Okay. When the matter is taken up, let the Board of Revenue take a call on this. Why should we do?
In a time bound manner.
Huh?
In a time bound manner.
The instant writ petition has been filed challenging an order dated 18/6/2012 by the Assam Board of Revenue, by the learned Assam Board of Revenue in case number R92 RAJ, J to bracket on, oblique 2012, whereby the learned Board of Revenue had admitted the said appeal and issued notice. The impugn order, which was put to challenge, had also been stayed. It is the submission of the learned counsel for the petitioner that the said order was passed why you are saying about limitation?
But this is filed after 2 months.
Can't be.
If my
The
lord,
order is of 9/4/2012.
Yes,
The
and this
order
is
is
filed
passed
on-
on 18/6.
12 June it was filed. There's about 2-3 days delay.
Then the learned counsel appearing on behalf of the petitioner submits that the learned Assam Board of Revenue had exercised the power had admitted the appeal even without condoning the delay of 2-3 days in preferring the said appeal. This court duly takes note of Regulation 151 of the Assam Land and Revenue Regulation 1886, whereby the Assam Board of Revenue, apart from having the power to condone the delay as mandated under section Regulation 147, has also the additional power to exercise the power of revision, to exercise the supervisory jurisdiction under section 151, under regulation 151. Taking into account the above, this court finds no reason or grounds for interfering with the order dated 18/6/2012 passed by the learned Assam Board of Revenue. The records for the reveals, records have been called for. আজি নি record টো? এইটো কি record নি? নহয়. Huh? The record further reveals that this court, by an order dated 28/6/2013, had stayed the order dated 18/6/2012. The said order stands vacated. The learned Assam Board of Revenue is directed to proceed with the adjudication of the said appeal. Upon issuing due notice to the parties, the registry shall communicate this order to the Assam Board of Revenue.
Some time limit.
Why? You take it up.
The board can be direct to decide it within four
You
months.
got this matter delayed. And now you are saying about the time limit.
Something.
And then 4,
Mr. Bolwa, you give your name in that case.
This is the disposition of the insurance claim regarding the accident of the vehicle.
Hmm?
Accident of the vehicle, my lord. On the ground that, my lord, the driver, license was, my lord, expired. My lord, I have prepared and wrote, my lord, in this regard. Yes,
Yes, what happened? Your vehicle has got, there was an accident.
accident.
Then what did you do?
My lord, we lodged
There was a
claim, my lord.
surveyor.
Yes.
Surveyed.
Claim was
Then your claim was repudiated.
repudiated on the ground.
And
my
then
lord.
you must have moved the ombudsman.
No.
Why?
At that time, my lord, we immediately come to the court, my lord.
Then why should I at all entertain this type of it?
My lord, here the technical ground is this, my lord, that whether the driver license was valid or not, my lord. He has two licenses. One private, my lord, and other is. And the definition covers, my lord, that.
Huh?
Definition of the motor vehicle tax, my lord, covers. That
The vehicle was? What type of vehicle was?
vehicle was a private service vehicle, my lord, carrying more than 9 plus excluding the driver.
What accident happened?
Yes. Accident, my lord, it was there. In front of the vehicle, my lord.
Somebody died?
Own damage.
Huh?
They claim for own
Own
damage.
damage.
Own damage. You have repudiated.
Yes,
Yes.
on the
Why?
ground that their public, their non-transport license was invalid.
Huh?
There are two parts in the driving license. One is for transport, another for non-transport. The vehicle admittedly is this private service vehicle. So the non-transport license was invalid at the time of the accident.
Non-transport vehicle.
Means non-transport validity of the license was invalid during that time. The transport part was valid. Regarding this, we sought a clarification from the DTO also. The DTO has replied at page 39, your lordship will get regarding the clarification.
Yes.
From
With
then
reference
the-
to that, I would like to inform you that
Yes.
separate validity of driving license is given in driving license in respect of two classes. Validity of 3 years in respect of transport, validity up to 20 years or attaining 50 years, whichever is earliest in respect of driving license from the date of issue. After 50 years, then an expiry of the validity of one of the driving license for the that to drive that particular class of vehicle with the expired driving license, also the validity in respect of driving.
So admittedly, they were not having that non-transport class of
Now, did he have a non-transport
he
license?
had a transport license was valid.
Transport means
Transport means driving of commercial vehicles
So commercial vehicle was allowed,
was allowed,
but
but the private part was not allowed.
so
So this vehicle was a private service vehicle. So on that ground, the company repudiated the claim.
under what provision you are doing it, you must be having it out there in your policy conditions.
The policy, your lordship,
Because
will
the
find
policy conditions only say that he has to have a license.
license.
Why are you repudiating it?
That time, the position
Did
was
you
not
come
clear.
up clearly that if you have a transport vehicle permission but no license and not a non-transport, this person would not be entitled to? Was it given?
No,
Is it there in the Motor Vehicles Act?
no, it is not.
Then how can you repudiate all these things? That's your case.
Well, two sections, my lord, the definition, if you lord to see, section 233 and 247.
Of?
That covers my.
Of the
Motor
Motor
Vehicles
Vehicles Act.
My lord.
Of the Motor Vehicles Act.
Motor vehicle.
Hey, Motor Vehicles Act. No, anyways, that is not a part of the
No.
terms of conditions.
Correct.
There is also, it is not mentioned out there in the insurance, in the Motor Vehicles Act,
Correct.
that a person holding a transport vehicle license would not be permitted, would would not be entitled to the insurance.
Well.
Yes, you are referring to which one?
233 part, my lord.
233.
Section 233. Private service vehicle. Well, not
Wait,
private
wait,
vehicle.
wait.
Private, that's different. Private service vehicle means a motor vehicle constructed or adapted
Two.
to carry
233.
section 2 subsection 33.
Oh, 233. It was private vehicle means a
Private
motor
service
vehicle constructed or adopted to carry more than 6 persons excluding the driver and ordinarily used by or on behalf of the man of carrying a person or so and so, but
Connection
does not
state.
include a motorway
That's
used
right.
for public purpose.
Now, if you also see page 247.
Yes,
Transport vehicle means public service vehicle, goods carriage, educational institution, bus, or a private service vehicle. So private service vehicle is included, my lord, in the private service. Light motor vehicle is a different, my lord. That is in section 221. 221, 220, motor car and light.
so his license. This one?
Page?
AS01, no, no, that is your
32,
card.
my lord. Page 30,
Page
32.
32. Very difficult to achieve.
My lord.
That was the valid license.
Transport was valid up to 24 2012.
20,
2012. 24. Looks
24,
like
24,
valid, no, valid till 2011.
2011
Oh,
non-transport one.
Transport is 24, 2012.
12.
Non-transport is 9/4,
9/4.
2011.
Yes.
And with a non-transport vehicle, non-transport is which we get
Yes.
normally. And the transport was valid at the time of the
Yes.
accident.
And another thing your lordship will see in the definition of private service vehicle says that means a motor vehicle constructed or adapted to carry more than 6 persons excluding the driver. But the policy here shows that it has a limit of 6 persons only. So if we go by the definition, there is policy violation.
Where is the policy?
Annexure 2, page 22.
Yes, where is it?
Number of persons your lordship will get 1, 2, 3, 4, 5, 6, 7.
What is he asking for? For damage of the vehicle?
He's asking for the damages.
Is he asking for any debt?
No.
Then why you are coming
Then-
into all these things?
And this is number of passengers excluding driver.
Excluding driver.
Yes, excluding driver.
The same thing is there in the definition. And light motor vehicle, my lord, that is different. That's 221 and 226. Definitely. Light motor vehicle and motor.
Your license is what?
That is light motor vehicle.
Where is it?
LMP. That is 221 light motor vehicle. is
Page
that-
32. Where does it show?
Light motor vehicle.
Class of vehicle.
Yes.
LMV.
L-
Then something LMGV.
GV. Then
Transport.
Yes.
TSV
T
bus.
bus.
Okay. The instant writ petition has been filed by the petitioner being aggrieved by the communication dated 5/9/2012 as well as the communication dated 6/11/2012 and further seeking a direction upon the respondent insurance company to entertain the claim of the petitioner in respect to the insurance policy bearing number 5307023111010 cited, cited 345 in respect of the vehicle bearing number AS01AN3943. From a perusal of the records, it reveals that the petitioner is the owner of a vehicle being Tata Sumo Victor bearing registration number AS01AN3943. The petitioner was further insured. The vehicle of the petitioner was duly insured with the respondent insurance company, with the respondent number 1, and was issued a policy bearing number, hey, number 2, I got the question, with the coverage period from 23/4/2011 to 22/4/2012. Next. On 19/2/2012, at around 6:45 a.m., an accident. The vehicle of the petitioner met with an accident on Bharatgaon Mayong PWD Road at Khantipur under Jagirod Police Station. This aspect, the accident was brought to the notice of the concerned police station, namely Jagirod Police Station, which was registered as Jagirod PS GDE number 468 on 19/2/2012. The respondent company was also informed about the said accident by the communication dated 20/2/2012. The petitioner thereupon approached the authorized dealer for repairing of his vehicle, and he was informed that and then had approached the authorized dealer for repairing of his vehicle. Full stop. Upon repairs being carried out, the total cost of the repairs worked out to rupees 1,51,898. It is the further case of the petitioner that during this period, when the vehicle was under repair, that is from 12/3/2012 to 28/5/2012, the petitioner had to incur an amount of rupees 1,14,000 to avail service of hired taxi for transportation of his staff. Accordingly, the petitioner had incurred a total expenditure as stated in the writ petition to the tune of rupees 2,65,000. The petitioner had lodged his claim way back, had lodged his claim on 22/2012 and subsequently had also informed the respondent authorities of the amount incurred by the petitioner. Be that as it may, the respondent authorities, by the communication dated 5/9/2012, informed the petitioner that as the driver's license was not valid at the time of the accident, the petitioner would not be entitled to the claim as so made. A further perusal of the said communication dated 5/9/2012 would show that it is the case of the respondent number 1 that though the driver of the vehicle had a driving license and the said driving license was valid up to 28/4/2012 for driving transport vehicle, but the said driving license was not valid for driving non-transport vehicle. It further reveals that pursuant thereto, on by another communication dated 6/11/2012, the manager centralized claims hub of the respondent number 1 company had formally informed the petitioner that the repudiation of the claim of the petitioner was based upon a communication issued by the DTO dated 1/9/2012 The petitioner being aggrieved has therefore challenged the communications dated 5/9/2012 as well as 6/11/2012 and sought for a direction for payment of the claim for reimbursement of the petitioner to the petitioner the costs so incurred for repairing his vehicle as well as other expenses. When the instant writ petition was filed, this court further takes note of that the instant writ petition was filed on 7/7/2013. This court issued notice on 27/9/2013. By an order dated 10/6/2015, the instant writ petition was admitted. The record further reveals that the respondent numbers 1, 2, and 3 had filed an affidavit in opposition on 23/4/2014. In paragraph number 5 of the said affidavit in opposition, it was mentioned that the accident occurred on 19/2/2012. And after verifying all the vehicular documents, it was found that the driving license of the petitioner was not valid, as he was authorized to drive transport vehicle only at the relevant point time of the accident. It was also stated that at the time of the accident, that is on 19/2/2012, the license for non-transport vehicle had expired. It was further mentioned that the vehicle in question is a private car and the driver did not have a driving license towards driving a non-transport vehicle. And in absence of the necessary endorsement in his license to that effect, he could not have driven the private car in question when the vehicle met with an accident. And as such, the insurance company cannot be settled with the liability. To the said affidavit in opposition, a reply has also been filed, thereby reiterating its statements made in the writ petition and denying to the statements as well as the contentions made in the affidavit in opposition. I've heard the learned counsels for the parties. This court had put a specific query upon Mr. S. Doctor, senior one or junior one?
Anyone?
The senior counsel representing the respondent insurance company, as to whether there is any condition in the driving license, in the insurance policy issued in respect to the petitioner's vehicle, that a non-transport, a transport, a license which is valid for driving a transport vehicle would not be permitted or would not be deemed to be a license for driving the vehicle in question. This court further inquired with the learned senior counsel as to whether the provisions of the Motor Vehicles Act 1988 prohibits a private vehicle to be driven by a driver having a transport vehicle license. Neither any conditions could be shown, nor any provisions was shown. No, neither any conditions were shown in the insurance policy, nor any provision was shown in the Motor Vehicles Act 1988, which do not permit the transport, a driver having a transport license to drive a private vehicle. On the other hand, this court, taking into account the provisions of section 230 bracket 33, as well as section 245, 47, 47, 2 bracket 47 of the Motor Vehicles Act 1988, wherein the term private vehicle as well as public vehicle have been defined. Private vehicle as well as transport vehicle. Private service vehicle, inverted comma, and transport vehicle respectively have been defined. Shows that a transport vehicle would also include a private service vehicle as defined in section 233 of the Act of 1988. Under such circumstances, it is the opinion of this court that the repudiation of the claim of the petitioner on the ground that the driver did not have a non-transport vehicle, though had a transport vehicle license, vehicle driving license, is bad in law. And accordingly, the impugn notices dated, impugn communications dated 5/9/2012 and 6/11/2012 are set aside and quashed. This court further directs the respondent number 1 to take a call on the claim made by the petitioner in respect to his vehicle afresh, without afresh, on the materials available, or to be placed by the petitioner if so desired, within 30 days from the date a certified copy of the instant order is served upon the divisional
Manager, my lord.
regional manager of the respondent number 1. But above the instant petition stands disposed.
Refer to another
Matter
writ.
before any other.
Deeply.
7.
Lordship, I am appearing on behalf of Counsel K.P. Pathak for petitioner. His on his legs at 4-5. The matter may be kindly asked
You
over
do
for
the matter.
Lordship.
You do the matter.
Lordship, I do not have the brief with me actually. Lordship.
We don't have the brief. No problem. Let me decide. It is an old matter. No, I don't. Nothing.
Lordship, just
2011 matter. Sorry.
Lordship, just a minor.
What do you want? What are you challenging?
Lordship, it's a challenge to the order of Information Commission
Yes, who is appearing for the state commission?
We don't have any record of this case. No file.
Fine.
Yes,
Lordship may just grant us 20 minutes time. I will get council K.
there's second copy to. You. I for what? Yes, you are doing it.
My lord, Mr. K.P. Pathak would be appearing.
Where is the
My lord, I passed it over for the
my
time.
second copy to कुछ second copy नहीं हैं? Give it to Mr. Borwa. I will read it. You appear for the state commission?
Yes, previously government was appealed. From the previous order, I can find out that government.
You
was
have the second copy of the petition? No.
Nothing.
Okay, take it. Yes, Mr. Pathak. What is your case here?
The issue is that a simple claim of the petitioner is that they are a cooperative society under the Cooperative Societies Act. That is why they did not come under the purview of the RTI Act.
So nowadays with the constitution bench judgment, does your case anything remains?
Lordship, I have the Thalapam Society judgment with me.
Huh?
Perhaps your lordship is referring Perhaps cooperative society, your lordship would still be exempted as per it. Because that issue,
Where?
I am relying on a judgment of 2013-16 SCC 82.
Everything has changed with that constitution bench judgment. That is the case of what is its name?
Lordship is perhaps referring to Subhash Chandra Agarwal.
What you mean?
I have not gone through the entire judgment, your lordship.
Go through it now. We'll
Very
pick it up at 2.
Very well.
But nothing remains now.
I have not, I
Because now with the Supreme Court, forget about anything else. Now the Supreme Court has to give you the divulge all details. You see, earlier that Bandopadhyay's judgment was there, which was a bit helps that certain things may not be declared and so and so on. But with this constitution bench judgment, it becomes very difficult.
I'll just go through the judgment.
I hope you can go through by 2 o'clock.
I will have
Something running into around
250
hundreds of pages.
250 pages, your lord.
Item 8. Yes, have you got the records?
No, please, Lordship. Lordship, we've already got the instruction from the department, and the copy is with me. The instruction.
record?
Yes, yes, Lordship. Lordship, however, my senior could not be present today, so the matter may be fixed on Thursday.
Yes. What was this case? Mr. Shah?
So it led to dismissal of the petitioner.
Huh?
And I had challenged Annexure 8 lordship.
Annexure?
Eight.
A.
No lordship, it's Annexure 6 law. Sorry, lord, it's at Annexure 5, page 17.
Yes, why are you punished?
Lordship, what had happened, lordship, I entered a voluntary retirement. There was a scheme, lordship, and I applied for it. And they state that lordship, it will be effective from 31/3/2001 lordship, that voluntary retirement. But then prior to that lordship, there was no. I was tried from my
Yes, what is your case?
Lordship, I was ill, Lordship, and that was known to the authorities, Lordship.
Hmm?
That I was ill, Lordship, and that was known to the authorities. But they did not consider that. While the
How did they know about it?
Lordship annexed 3, Lordship, this was the certificate, Lordship, that I produced before the authority.
Hmm?
Page 15. This was the certificate.
Now, Mr. Sharma, what remains in this petition to be decided now?
Lordship, since the.
You have been dismissed,
Yes,
and that happened in the 2000. When?
2000, 2001, Lordship itself. there was
2001.
Order passed.
You filed the writ petition in 2011. Why?
Lordship, it's the wife, Lord. Approach this. Since
Why?
since the pensionary benefits were denied,
Understood. Why did you approach in 2011?
Lordship, in pensionary cases, Lordship,
So what?
time bar may not be.
No, you have been dismissed from service in 2001. You approached after 10 years. Why?
Lordship, the wife of the petitioner
Huh?
is not that literate, Lordship, and she,
Petitioner is not literate.
yes, Lordship. It's the
What
wife-
was he working?
was the wife of the petitioner who is.
Huh?
The wife of the petitioner is there.
This has been filed by whom? The wife of the petitioner.
Earlier, Lordship, he had approached.
Earlier it was okay. The petitioner filed it. The petitioner died.
Lord.
Now you are concerned with the pensionary benefits now. But why was the writ petition filed in 2011?
Lordship, the delay may not be.
Huh?
considered. The Lordship may not go into that aspect, Lordship, because.
Why?
since
Why should this court not go into that aspect that you have approached for 10 years?
Lordship, since he was suffering, Lord, for
Who was suffering?
the petitioner. The
Where is the document?
certificate, Lordship.
Huh?
This certificate, Lordship, page
Where?
15. Page 15.
Page 15. This happened in 2000 only.
Lordship, it was viral hepatitis. He was suffering all along.
Now, where is any explanation after 2001?
Lordship, he continued to remain in touch with the authorities, Lordship.
So
and
this is what Mr. MP Sharma says.
it continued till 2006, Lord.
Huh?
It continued till 2006, Lord.
Where is it?
It's page 21, Lord.
Now, why have you approached after so many years? A single explanation. Why should this court at all take into account all these things?
Lordship, paragraph 10 is the explanation. It's at page 7, Lord.
Hmm?
Paragraph 10 of this writ-
Paragraph?
10.
Yes. Of?
this reputation.
Yes, tell me.
The petitioner states that financial hardships and deteriorating physical condition restrained him from approaching the court earlier. Now, having received assistance from his friends and relatives and his health condition improving, the petitioner has instituted the present proceeding. The delay occasioning in preferring the instant application is not deliberate but a result of
So it is not on account of health grounds.
deteriorating physical condition.
So it is on deteriorating physical condition. What is this physical condition?
Due to his health only.
Enough. Think you have to again get us some more money for going in the pit. It's not a fit case. The instant writ petition has been filed by the petitioner challenging the order dated 2/6/2000 1, whereby the petitioner, whereby the original petitioner, Gautam Thappa, bracket since deceased, was dismissed from service, as well as also the order dated 22/2006, whereby the appeal so filed by the petitioner was also dismissed. And the application so filed by the petitioner for reconsideration was also dismissed. The facts stated in the writ petition is that the husband of the petition, before before dealing with the facts, this court finds it relevant to observe that the original petitioner expired on 2/10/2011, and thereupon an application was filed by the wife of the original petitioner seeking substitution, which was allowed by this court dated 11/6/2013. Taking into account the above, this court proceeds to deal with the facts of the case. For the sake of convenience, convenience, this court refers to the original petitioner, late Gautam Thappa, as the original petitioner, and his wife, Srimati Dilmoya Thappa, as the substituted petitioner. The facts as could be discerned from the pleadings is that the original petitioner was enrolled as the rifleman of the carpenter in the Assam Rifle with effect from 21/6/1980. Subsequently, he was promoted to the rank of clerk and thereafter to the rank of Nayak clerk. In the year 1996, the original petitioner was promoted to the rank of Havildar clerk. In the year 2000, at the instance of the petitioner, a proposal was mooted as regards his voluntary retirement, and consequently, the Director General Assam Rifles, by an official communication dated 11/8/2000, approved the voluntary retirement of the petitioner with effect from 31/3/2001. It further reveals from the record that It was the case of the petitioner. That the petitioner was suffering from viral hepatitis with alcoholic psychosis, ESYCROSIS, and was admitted at the Margarita Central Hospital during the period from 7/12/2000 to 12/12/2000, and was under medical supervision for the said medical condition till the month of February 2001. On 23/2001, the senior medical officer of Margarita Central Hospital had issued a medical certificate declaring that the petitioner to be fit to attend his duty, upon which he joined his duty on 24/3/2001. The petitioner was duly, the original petitioner will live. The original petitioner was duly allowed to join his duties on 24/3/2001. However, to his utter shock and dismay, a notice of summary court-martial proceeding bearing number S/02/2001 dated 25/5/2001 was issued by the Commandant Headquarters, Tripura Range, Assam Rifles, which was served upon him. It was further mentioned that the petitioner, it was mentioned in the said notice that the petitioner would be tried by the summary court martial, which shall commence at 11:30 hours on 2/6/2001, and further that on the date he would be subjected to medical examination at 8 hours, 0800 hours, and shall be produced in the court at 1115 hours. Thereupon, a summary court proceedings was held on 2/6/2001, and on the said date, a memorandum bearing number 309/73 the Commandant Headquarters, Tripura Range, Assam Rifles, reduced the rank of the petitioner to rifleman and further proceeded to dismiss him from service. The charge which was brought against the original petitioner was that though he was granted 25 days early with effect from 16/10/2000 till 12/11/2000, but he failed to report back on due date and remained absent without leave and intimation till 24/3/2001, thereby a total absence of 132 days. The petitioner was further informed by the said order dated 2/6/2001, by another communication dated 2/6/2001, that he may prepare a petition before the appropriate authority against the award issued by the memorandum dated 2/6/2001. The petitioner thereupon filed a representation after almost 5 years thereafter, on 6/2/2006, before the Directorate General, Assam Rifles Record Branch, praying for cancellation of the memorandum dated 2/6/2001, whereby the petitioner's rank was reduced to that of the rifleman, and further his services were dismissed. The petitioner further prayed in the said representation that he may be allowed to go on voluntary retirement in terms of the official communication dated 11/8/2000 on a sympathetic consideration of the matter on humanitarian grounds, reckoning the 21 years of dedicated service rendered by him, and in view of his family consisting of his aged mother, wife, son, and 3 daughters, all dependents on the income of the petitioner. It was also mentioned in the said representation that the petitioner, the original petitioner, went on casual leave for a period of 15 days with effect from 16/10/2000 to 2/11/2000. However, owing to sudden illness, he requested for a further extension of 10 days extension, which was accordingly granted till 12/11/2000. Thereafter, as he was suffering from viral hepatitis, he had not completely recovered from his sickness and as such could not report for duty on expiry of the said leave and stayed at home without intimation for further extension. Next. The representation of the petitioner, however, was rejected by the order dated 22/2006, thereby intimating the petitioner, that original petitioner, that his case has been examined in details, and from his service record, it could be seen that he was dismissed from service under Section 39 small b bracket of the Army Act 1950 for overstaying leave without sufficient cause. And as such, the punishment imposed upon him cannot be considered into the charge, and hence he is not entitled to get any pensionary benefits as per Rule 24 of the CCS bracket Pension Rules 1972. Thereupon, after another gap of 5 years, the instant writ petition was filed on 17/2/2011. This court further finds it relevant to take note of that this court, by an order dated 4/3/2011, issued notice making it returnable by 8 weeks. Thereupon, by an order dated 7/10/2013, this court issued rule The record further reveals that an affidavit in opposition was filed by the respondent numbers 1, 2, and 3. In the said affidavit in opposition, it was mentioned that in the month of July 2000, the original petitioner had submitted an application to proceed on voluntary retirement, which was admittedly approved by the competent authority, fixing his date of retirement with effect from 31/3/2001, bracket A/N, bracket close, by the communication dated 11/8/2000. It was further mentioned that necessary casualty was published by Part 2 Order, serial number 50/2000, dated 25/9/2000. However, the same did not come into force because a disciplinary proceedings was initiated against the petitioner for his unauthorized leave. It was further mentioned that the petitioner had requested for 15 days casual leave on compassionate grounds, which was granted with effect from 16/10/2000 to 2/11/2000, with a further permission to extend 10 days earned leave with effect from 3/11/2000 to 12/11/2000. However, on expiry of the said granted period, the original petitioner failed to report on duty and he was remained absent without leave till he reported back voluntarily to headquarters Tripura Range, Assam Rifles on 24/3/2001. As such, the total period of absence was 132 days. Under such circumstances, the petitioner was charge sheeted, and after hearing of the charge, a summary of evidence was recorded. Thereafter, with due compliance of the Army rules and the Army Act, the original petitioner was tried by a summary court-martial held on 2/6/2001 under Army Act Section 39B for without sufficient reasons cause overstaying leave granted to him. It was further mentioned that there was a detailed investigation carried out and applying all the legal provisions of the Army Rules 115(2) as applicable to the Assam Rifles personnel operating under the operation control of Army. And after hearing the charge, the summary of evidence was recorded and the individual was tried by a summary court martial held on 2/6/2001. The petitioner was found guilty under the Army Act Section 39B for without inverted comma for without sufficient cause overstaying leave granted to him inverted comma close and sentence him inverted comma open to be reduced to rifleman and dismissed from service inverted comma close on 2/6/2001 by memorandum dated 2/6/2001. It was further mentioned that the petitioner being aggrieved had prepared a post-confirmation petition dated 2/6/2006 for cancellation of the memorandum dated 2/6/2001. 6/2006 for cancellation of the memorandum dated 2/6/2001, thereby reducing his rank to that of a rifleman and further dismissing him from service, and allowed to go on voluntary retirement on humanitarian grounds, reckoning that 21 years of dedicated service rendered by him in view of his family. The said representation petition dated 6/2/2006 addressed to the Director General Assam Rifles Record Branch was examined in detail, and previous records of the petitioner was also taken into account. And accordingly, the said representation was rejected. In paragraph number 10 of the repetition of the affidavit in opposition, it has also been mentioned that during the summary court-martial proceedings, the petitioner had also pleaded guilty before the summary pleaded guilty, and accordingly he was awarded the sentence inverted comma to be reduced to a rifleman and dismissed from service. This court, upon perusal of the materials, had heard the learned counsels on 1/8/2023. During the course of hearing, a question arose as to whether the petitioner was a habitual offender, inasmuch as it has been mentioned in the order, impugned order dated 2/6/2001, that the petitioner was a habitual offender as he had overstayed leave on 3 occasions in the past, for which he was punished to mend his attitude. Under such circumstances, this court directed the respondent authorities to bring on record as to whether the petitioner was a habitual offender prior to be charged for overstayed leave for 132 days. Miss, your name?
M. Konyak Deblo.
So and so, the learned counsel appearing on behalf of the respondents today have produced the communication issued by the Lieutenant Colonel SO1 bracket A for DIG Assam Rifles, dated 23/8/2023. In the said communication, it was mentioned that as per the records available in the punishment register of the establishment branch of the said secretariat headquarters, the original petitioner was awarded severe reprimand under Army Act Section 63 for 58 days. What is AWL? Huh? What is AWL? Mr. Sharma,
Say it right.
without leave is okay. Absent, 58 days absence without leave, bracket AWL. And in that regard, the photocopy of the page of the punishment register was enclosed. It was further mentioned that there was no other record of any previous punishment awarded to the petitioner, original petitioner, with the headquarters. The said communication is kept on record and marked with the letter X. I've heard the learned counsels for the parties.
These 58 days, Lordship.
Let's see the Army Act. You have come without the Army Act.
Sorry.
Mr. Sharma, you should be more diligent to your client.
Lordship will, if upon perusal of this, Lordship, the sheet they have used, Lordship will find
Now, you see, the punishment under 39 is conviction, liable to suffer imprisonment for a term which may extend to 3 years or less, punishment. heard the learned counsel for the parties and have perused the materials. From the perusal of the materials on record and taking into account that the petitioner had been found, the original petitioner had also pleaded guilty to the charge of unauthorized for overstaying the leave granted without sufficient cause. It would be an offense under Section 39B of the Army Act 1950. Further to that, it seemed from Section 39 of the Army Act 1950 that the person shall, on conviction by court-martial, be liable to suffer imprisonment for a term which may extend to 3 years or such less punishment as mentioned in the said Army Act. This court further finds it relevant to take note of Section 71 of the Army Act 1950, where amongst the various punishments where it has been stipulated that punishments may be inflicted in respect of offenses committed by a person subject to the Army Act 1950 and convicted by court-martial according to the scale following, that is to say, convicted by court-martial according to the scale mentioned therein, which includes dismissal from service. In that view of the matter, taking into account that the original petitioner, have already been convicted upon pleading guilty to the offense under Section 39B, the imposition of penalty under Section 71 for dismissal of the service of the petitioner cannot be said to be arbitrary and unreasonable. More so when it is seen that on an earlier occasion also, the petitioner was punished for being absent without leave for 58 days. Considering the above, this court finds no merit in the instant writ petition, for which the writ petition stands dismissed.
Lordship, this record which they have produced, Lordship, herein, Lordship, the period is from April 2000 to June 2000, Lordship, meaning that, Lordship, April 2000 to June 2000, Lordship, he was ill during that point of
Huh?
during that point of time, he was not well, Lordship, because it's from April 2000 to June 2000, Lordship.
Do you have given any certificate?
Annex 3, Lordship.
Take those grounds out there in Indian.
Lordship,
Sure.
otherwise, this absence of 132 days, Lordship, it's disproportionate for that dismissal, Lordship. Or, Lordship, he has rendered at almost 20 years of that part. And considering that, Lordship, during the
Yes,
time
Sharma.
of his illness, Lordship, at least something may be granted apart from the dismissal, Lordship.
Court number 1,
Lordship can always do it, Lordship.
I am not.
Around 19.
Obliged, Lordship.
You can do it. Where is he? On the last occasion, I asked them to find out something else. What did I ask, Mr. Oh, region, industry and region.
Oh, yes.
Yes, where is it? Mr. Bhattacharya, kindly call your senior government advocate who was appearing earlier. Yes.
Two judgments that I have referred.
Hmm.
That is, the Lord will file 62 to 67 page and 68 to 76
French motor.
French motor.
Where?
French motor and Ripton.
Which paragraph? What was the issue involved here?
Like in
It
this
arises
case,
out
the
of
issue was
industrial
for
between the
fixation of
and
weight,
where
salary.
who matters.
Now, your so far French motor is concerned, page 62.
Journey.
Your Lordship can come to para 3. The contention on behalf of the appellant is that the wages are fixed and industry cum region basis, and the tribunal went wrong when they took account of the compensation industry.
But this is only as regards wage.
Wait,
How can we bring the wage concept into a age? By removing the W.
no, that is the problem. Actually, your Lordship come to next judgment. I shall come to that aspect.
Hmm?
I shall come to that aspect.
Page?
Page 68.
Hmm.
Para 5, it is also age. Para 5
Yeah.
and para 6. Here it is indicated.
Eh, The first question, therefore, which calls for decision is whether the tribunal went wrong in not following the industry cum reason and in leaning into the recommendation of the tripartite committee. It's true that the tribunal begins with the award with regard to the minimum wage. Para
Para 8 and para 5 and para 6 both. The main contention of the appellant, however, is that the tribunal has gone wrong in applying the industry cum region formula, which is the basis for fixing the wages and dearness allowances, and has made comparison with the concern which are not comparable. It is also used that the tribunal has relied more than one reason aspect the industry cum region formula, and not only the industry aspect within the when dealing with the clerical and subordinate staff. And in this way, and in this, it went to wrong. Reference of this connection is made in two decisions of this court, namely, for such and such and such and such, was more applicable to the present case, and the principles laid down in the French motor car and in Hindustan motor case, in this case observed that there was ordinarily desirable have to have main much uniformity possible as the wage scales and etc. So your lordship come to the bottom portion. The principle therefore emerges from these two tribunals could have been traced on the industrial part of the formula, and if there are a large number of concerned the same region carrying the same industry, such case in order to that production cost etc. True. No, yeah, if your lordship come to page 63, para 3.
Para
3.
page
63. That is French
63.
motor
You
cars.
are again going back to French court. No.
Yes, sir. Let us come to French motor cars. Para 3, my lord. The main contention on behalf of the appellant is that the wages are fixed on the industry cum region basis, and the tribunal went wrong when it took into the account for comparison the industrial concerns which are entirely dissimilar to the appellant. It is very important. It is now well settled that the principles of industry cum region has to be applied by an industrial court when it proceeds to consider questions like wage structure, dearness allowance, and similar condition of service.
Mr. Dasgupta, are you inferring that the similar conditions has to be read as the age also?
Yes.
No. Similar would be in respect to wage. Dearness allowance has to go along with that. This is as regards the wages. How can you bring the age aspect up? Age is different.
Any condition of service which is not apparent from the any settlement.
No. When you are using similar, the word similar has to go. First of all, you can't read the judgment of Supreme Court or any judgment as a statute.
Yes.
So it has to be read in that context. The context out here is the wage. Then how do you bring the age concept out?
Each concept was considered in confront with the eight judgment. Confront with the
Now, I asked you to also find out another aspect of the matter as to if the draft rules are prepared and in view of the affidavits of five, can this court, for the time being till the draft rules are finalized,
there is a judgment I have got it. Get this.
where is it?
So for this industry cum region formula rule, I will give it to you a lot.
That is the only way.
No, that is also that your lordship will find at page 116 to 119.
Yeah. When
They-
can
they
be
take
followed?
judgment
Well, if the draft rules are intended to be notified in near future, they can be followed in the near future. They cannot, however, be followed if there is no intention. This is because they are required. But the rules cannot include the jurisdiction of the competent body to regulate service provision.
Paragraph 6. Take judgment with you. Copy accept. Based on this judgment, another judgment was delivered by same page. Few days after, 10 days after that.
But here we are concerned with 18 years. 18 years. 18 years.
Oh.
There the Supreme Court you can't notify after 8 years. Where is
No,
the
but
senior judgment?
if we
Who their affidavit, Milord, they have indicated.
Understood. But don't you think that this court should keep the matter pending, directing them to notify, allowing them some time to notify? That is the way out. Because they are saying this. There I may say, okay, 58 on the basis of this judgment. But this judgment also says that if our draft rules have not been notified for 8 years, court applying the yardstick there would not be proper.
May I read this
Hmm.
paragraph? The draft rules were prepared in 1983 and since then they have not been enforced. It is no doubt open to the government to regulate the service conditions of the employees for whom the rules are made by those rules. Even there, the draft state, provided there is a clear intention. Well,
Clear intent.
Provided, provided there is a clear intention on the part of the government to enforce the rules in near future.
Then
Recourse to the draft rules is permissible only for interim to meet any emergent situation. Again. But if intention was not to enforce or notify the rules at all, this is very much clear, at all, as is evident in the instant case. Exactly so, Milord. As a recourse of draft rules cannot be taken, such draft rules cannot be treated as the rules made under Article 309 of the Constitution. Now, next judgment is, Milord, is that by the same bench after 7 days after this judgment was delivered.
there also 8 years they have not. 8 years they have not.
Yes.
And as such, the Supreme Court says that as you have not done for 8 years, so it is evident that one cannot rely upon these draft rules.
But in their affidavit, no, they have stated categorically.
Now only they are saying, because this court have caught them. Otherwise, they were very silent, isn't it? That is why I need the senior government advocate. That is the only way out. Where is it?
He is suffering from eye flu, Lordship. He is not coming court.
Okay, we'll take it after 7 days then. Because that is the most important thing.
But so far, industry come region principles which is applicable in the high for the retirement, I will give some judgment.
Yes, you give. But that, as of these judgments would not help you. But that is the only way out. Provided there are two ways. This court may rely on the draft rules. But relying on the draft rules now, they may not do anything. They'll keep quiet.
But they have said in the categorically in the affidavit. Anyway, let us.
His affidavit was filed by one person. They say that, "Oh, how do I know? That
Anyway,
person may have stayed.
But second contention before,
Election, all these aspects are there. Let us see what stand do it to.
second contention, what I would like to place before your lordship is that the industry come region principle is a pertinent principle.
Understood. But if we apply that, then many other aspects will come in. Not
Two
only
things.
the age.
One thing is industry,
Understood.
other thing is region. So for the
You
way it
see,
is
the
concerned,
principle of-
industry is essential.
Understood. The industry of the principle of industry come region would be made applicable to apply the central rules. Because in the in a central government undertaking in the state, the age is 58.
58.
So the same should be applied.
Yes, because we have a large number of industry in Assam. Say a Guwahati oil refinery, Digboi oil
No,
refinery.
understood. Now, if we,
Numaligarh
do
oil
that,
refinery,
if we do that, industry come region out here.
region, we can bring this region concept here. Because your lordship, the FCI, there are a number of FCI godowns throughout the state of Assam, where this standing order is applicable. And in this standing order, it is specifically stated unless there is any settlement, the retirement age will be 50. Guwahati Oil Refinery, Numaligarh Oil Refinery, Bongaigaon Oil Refinery, Digboy Oil Refinery, Coal India Limited. All these things, all these industries are there. They are regional industries. More than 20 or
Because
20.
these two judgments, French Motor and the other,
No,
are judgment on wages.
actually I thought.
These are on
Yeah,
wages.
no, I have gone through those judgments. Your lordship might take it granted that there is a principle. I
Let
will
me
give
fix
it.
it again on
Yeah,
but-
because your lordship is supposed to.
14th of September.
Because I am about here.
Huh?
There are judges.
Just find out that. Yes, that is another principle we can apply. But
Region here, so far age is concerned, industry is not pertinent. Region is pertinent. So far wage is, sorry, I'm sorry. So far wage is concerned, industry is pertinent. Similar type of industries, but because there is a competition between the industry. So for that purpose, industry is important. But so far the age is concerned, the industry is not very important, but the region is important. Now we have to look into whether what are the retirement age of the other industry. Now, right at present, officially, I cannot produce any document.
no, you see what happens, the problem which will apply is, as of now, they don't have a draft standing rules. They have even not amended in their rules, bringing in the age, which is there in the central rule. By
No,
which state,
by this draft rule, they have made an amendment.
we don't have that. So they have a rule of 1947, where they did not incorporate, which was done in the central rules of 1946 in 83.
1983. Yes. That is, I have seen.
So
yes.
it is for the state of Assam that is not brought within the schedule, the
Ah,
age. You see the problem which arises there.
10A and 10B that was incorporated by the
Yeah,
central
that
government.
is not there. So for Assam, the Standing Orders Act does not have that aspect in the schedule.
Yes, correct.
So can this court apply the rules,
Draft rule.
no, the rules of the central government,
According
not
to-
only a age or as regards the age, without an corresponding application of Rule 10A?
For this purpose, I want to bring the decisions of this region commander.
No, that is why. If we, that is the problem
That
is there.
only way.
It will also amend. This court will be amending by taking the industry come region formula, amending the rules.
No.
No, yes, amending the 47 rules by bringing in, by amending the schedule to the act. Think about it. It has certain consequences. So the best one is the drift one. This draft rules can be taken into account. And if this court takes it up with the government and gets it notified, matters. That is the only way out.
I will bring it up.
Supreme Court has decided is what is a public authority, then whether the information sought for it is private information or public information. If it is private information, what circumstances it has that private right to privacy has to give way to the public interest, and in these circumstances whether the information sought for regarding the judges of the Honorable Apex Court, whether that can be provided on. What the Apex Court has held, your lordship, is that since the Supreme Court is a body created under the Constitution and the judges exercise office under the Supreme Court, so that is public information. The Supreme Court is the public authority, and the information has to be given. But in the judgment which I am referring to, your lordship, that judgment was also referred to in the Constitutional Bench judgment. There, the issue was, your lordship, whether a cooperative bank registered under the Cooperative Societies Act, whether it would be amenable to the RTI Act, in as much as whether it is a public authority. So if it is not a public authority, then that goes to the very root of the matter. Then the subsequent discussions by the Supreme Court regarding the public information, private information, that need not be gone into, because the bank, the body itself is not a public authority. So may I take your lordship to that judgment one? In this matter, this Thalapam Bank Service Cooperative Bank Limited, it was agreed because it was held to be a public authority, and then the Honorable Apex Court had a occasion to discuss whether under Section 2H of the RTI Act,
Yes.
before going to the judgment, if I may just take your lordship quickly to the provisions of the RTI Act itself, your lordship, 2H, what it says is public authority
Yes. Two,
2F and 2H, your lordship, those will be relevant. 2F defines information, your lordship. It says information means any material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form, and information relating to any private body which can be accessed by a public authority under any law for the time being in force. And the term public authority is defined in 2H. Public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by any law made by Parliament, by any other law made by the state legislature, by notification issued or order made by the appropriate government, and includes any body owned, controlled, or substantially financed, non-government organization substantially financed directly or indirectly by funds provided by the appropriate government. The Lordship, our stand is that the Apex Bank is not a body created. It is though it's a body governed by a statute, it's not a body created by a statute. So if it is not created by a statute, your lordship, it would not be a public authority under the act. And on that,
how are you created?
we are a registered society, cooperative society under cooperative societies.
You are registered. How?
Under the Cooperative Societies Act, under Section
How is
11.
your formation?
The formation is under the bylaws, your lordship, framed under the Cooperative Societies Act. And this judgment of
But
the
we have an existence beyond the cooperative society. Let's take it that you don't have a cooperative society. You have an existence.
no, our existence is we draw our existence from the Cooperative Society.
Then
So our activities may be beyond the ambit of some activities may be beyond the ambit of the act because we are a
that
financial.
is a different thing. But you have an existence
No, we do.
beyond the cooperative.
We do not have an existence beyond the act.
Why won't it come within the within the ambit of 2HC?
What the Apex Court has held, your lordship, is that bodies which are created under a statute, there is a difference between bodies which are created under a statute and bodies which are governed by a statute. Your lordship. So we are a body, your lordship, which is governed by a statute.
Apex Court was taking into account 2D2, 2HD2,
2HD2, yes,
non-government organizations substantially financed.
yes.
We are not concerned here. Therefore, my specific question is whether you would not come under
We
2HC.
would, my submission will be we would not, your lordship, because
Why?
though we are, because under the act, your lordship, the body which has been created is the Registrar of Cooperative Societies. Now, the Registrar of Cooperative Societies is a private, is a public authority. But we are a body, though created under the provisions of the act, your lordship, and registered under the act, we are not a public authority because we are only governed by the provision. We are not created by the act. Your lordship. We are created under the provisions of the act, not by the act. Your lordship. fact, in paragraph 18 of the judgment, your lordship, even the apex court,
You come under the 2007 Act or the
yes,
1940
2007 Act,
or the 1940
2007. We have made a,
Gandhi. Are you not the apex bank?
we are the apex bank, your lord.
Then you were registered under the 49 Act.
The pleadings say, your lordship, specifically, though the registration certificate is not there, your lordship, the pleadings, 1949 Act, 1940.
Now 1949 Act, it is required because if you are under the 2007 Act,
Yes.
then in that regard, the entire formation of the board,
Yes.
the management,
Yes.
is in terms with that. There's no running away. The tenure of that, tenure of the board. The election to the board
Those are regulated by the act, no doubt.
and the bylaws are made subservient to the act.
They are, your lord, they are,
That is 2007.
2007.
Now, can you say that as regards you were registered under the 1649 Act, you are registered in terms with your formation is on the basis of similar to a society?
That is what we have stated in the, that is the foundation of our claim. That since we are a
So are you saying that you are parameteria to a society registered under the Registration Act?
Yes.
Society's Registration Act.
in fact, we have said that we are a society registered under the society's list.
But in respect to the societies registered under Societies Registration Act, the question will be different.
Cooperative societies list.
No, that is a different thing. I'm not on that. I'm 1860 Act.
Not-
There, it is subject to the bylaws, the memorandum.
Yes, sir.
If you see the provisions out there, it is always subject to the bylaws.
The 2007 Act. Your lord.
No,
19
1860.
Yes.
A society which is being formed under the 1860 is subject to the bylaws.
Yes, sir.
The act is subject to the bylaws.
Yes, sir.
But whereas for a cooperative society, it is not subject to the bylaws. The bylaws are subject to the act.
Yes.
There's the material difference on that.
Yes, your lord. Yes. The bylaws are subject to the act.
So therefore, 2 days back, I was taking up the 1949 Act. There, the AGM forum. You may have a bylaw, but the bylaws is subject to the act.
Same is in the 2007 Act. also.
But that is not what is there in 1860.
It is not.
So the society is regulated by its own bylaws. Now, therefore, if you take into account the BCCI judgment, the BCCI judgment has been held to be, BCCI now has been held to be a public authority.
Public authority.
Now, if it is a public authority, even being a society, under the 1860,
Yes.
now can you say that you are not?
In this act, your lordship, though our bylaws are subservient to the act, there is no dispute on that. But what the act provides is that the exact language is, I'll just have to check if there is a parameter provision in 1949 also. 2007 Act specifically says,
No, don't go by the 2007.
I'll just. I'll just take out the section.
Because you cooperative totally late. Cooperative. Followed by some. And I equal to 2007. Now, if you see the earlier act,
Yes.
13, amendment of the bylaws of a registered society. No amendment of a bylaws of the area, whether by way of addition, alteration, or area rescission, shall be valid until such amendment has been registered under this act. Now,
Lordship is reading from it.
14 says, power of the register of the affiliating society or the financing bank to direct amendment of the bylaws or adoption of the rules of procedure.
Power of the register.
Now, what has happened as regards the repealing of this provision? Every society existing at the commencement of this act, which have been registered under the 49 Act, shall be deemed to be registered under this act. And its bylaws shall, insofar as they are not inconsistent with the provisions of this act, continue in force until altered or rescinded, and shall to such extent be deemed to be registered under this act. All appointment rules and orders made, notifications and notices issued, all transactions entered into, and all suits and proceedings instituted under the said act shall continue and shall so far as so and so. This is the saving. Now, as regards this, now you come under the 2007. Now, 2007, the bylaws are subservient to the Act.
The bylaws are subservient. But what I'm trying to get for your lordship is that bylaws now again are created by the power to amend the bylaws are with the General Assembly. Act provides that the supreme authority regarding the functioning of a society lies with the general authority. And on the basis of that same reasoning, your lordship, the apex court has held that when the under section 29(4), your starts with the
Tell me.
since the supreme authority regarding the functioning is with the society, is with the General Assembly, the society is with the General Assembly. Then your lordship, drawing the same reasoning that applied by the apex court, perhaps we can say that we are a body which is regulated by a society, its actions are regulated by society, governed by the act and the authority created under the act, but we ourselves are not a public authority. That way, lordship, if that analogy is applied, then every company framed under incorporated under the Companies Act, your lordship, that will also be a public authority. Because it is framed under the act, they are incorporated under the act, your lordship. Act created by Parliament. By the definition of 2(8), every private company will also be a public authority then, your lordship. That is perhaps why the apex court has tried to distinguish between bodies created under an act and bodies governed by an act.
But you can amend your bylaws.
We cannot. We can with the under the procedure, if we follow the procedure laid down in the act. But we have to get it approved by the registrar.
No, unless it is registered.
Yes, there is a procedure laid down only after final approval of the registrar with the bylaws.
Then only you can amend.
Yes, that is.
So you are saying that for the purpose of the internal affairs of the society. It can't be termed to be a public authority.
In fact, if a person wants some information regarding the society, which is readily available with the public authority created under the Act, which is the register, then if it doesn't fall under any of the exceptions later under the Act, then the registrar will be bound to disclose that information. For example, if somebody asks when was the last AGM of this society held, or something
Let us see what is the information sought for.
the information application is at page number 28 here.
Yes. Whose possession is the Bolero SLX 2 car so and so at present? What is the name of the driver of the Bolero LX car? So and is the state driver an employee of the Assam Cooperative Bank, and who pays the salary of the state bank? Who pays for the maintenance and the fuel charges of the Bolero access car? Certified copies of all bills, documents, and this has been filed before the managing director.
Before the managing director of the FX.
Then what happened?
Then, Your Lordship, we referred the matter.
The issue as to whether the FX will be the cooperative bank is under the RTI pending before the Assam Commission cannot be given. Complaint for closing of state commission. Perusal of the you file, John the prepared government.
We are challenging the order.
And there is an order being passed on to them. Review application. So where is the review power? Is there a power of review?
Doesn't specifically, there is a power. The order at page 36, Your Lordship, would perhaps reveal the mind of the authority.
This is the order.
Yes, of 23/12/2020, 2010.
Let's see the judgment of the Supreme Court. Let's see what is it we are dealing with also in the Supreme Court.
Yes.
The cooperative society registered under the Kerala Cooperative Society would fall within the definition of public profit. Now let's see the findings.
At para 18, Your Lordship.
We may first examine para. Para 18.
Right. We can therefore draw a clear distinction between a body which is created by a statute and a body which, after having coming into existence, is governed in accordance with the provisions of a statute. The societies with which we are concerned fall under the latter category, that is governed by the Societies Act, and are not statutory bodies, but only body corporates within the meaning of Section 9 of the Kerala Cooperative Societies Act, having perpetual succession and common seat, and hence have the power to hold property, enter into contract, institute and defense suit, and other legal proceedings, and to do all things necessary for the purpose for which it was constituted. Section 27 of the Societies Act categorically states that the final authority of a society vests in the general body of its members, and every society is managed by the managing committee constituted in terms of the bylaws as provided under Section 28 of the Societies Act. Final authority so far as such types of societies are concerned, as the statute says, is the general body and not the registrar of cooperative societies or state government.
There you fall into the ditch. You see, just for example, an AGM is held.
Got it.
Is the AGM an AGM without the approval of the register?
The minutes have to be approved by the registrar.
Is it required as per this?
So I do not have the exact provisions of this act before me, Your Lordship, but Section 27, what is narrated in this paragraph, it appears to be somewhat similar to Section 29(4) of our Act.
We are concerned with the 69 Act.
Perhaps since now it's the 2007 Act, Your Lordship, we can go.
Oh, no. We are concerned with the 69 Act. Let's see. Of the Kerala.
Kerala, yes, I do. Kerala. Cooperative.
You're concerned with section 27.
27.
Subject to the provisions of this act, the rules and the bylaws, the final authority of the society shall rest in the general members of the body of the members, provided that nothing contained in this subsection shall affect the exercise by the committee or any officer of a society of any power conferred on such committee or such officer by this act or rules or the bylaws, notwithstanding anything contained where the area of the operation is not less than such area as may be prescribed, or where the society consists of not less than such members so and so, to exercise all or any power of the general body as the so and so. That the representative body shall not alter any provision by the bylaws relating to its constitution so and so. Exercise of any power by the representative general body shall be subject to strict restrictions as may be specified in the rules or the bylaws. Let's see our provision now. Where is the final authority?
Our provision it will be 29(4) here.
Subject to the provisions of this act, the ultimate power of the coverage shall vest in the general. Supreme authority shall, however, vest with the state government. Order raised as the case may be during the pendency of any loan or service to the Imam. Any power function responsibility falling within the scope of the cooperative society or the body corporate, which has not been specifically entrusted by this act of the by the general. Where is the power that of approval of the register?
Yes.
Let us see the power and functions of the board. The board shall discharge such power, clause section 38. Perform such duties, exercise such powers as may be specified in the bylaws and in accordance with the terms and conditions laid down therein, and in particular the board shall have the following powers, functions and duties. Mr. Pathak, I think we should also get hold of the corporation department. Because they
One
will
aspect-
be also relevant
Yes. sir.
for
The bylaw-
deciding this issue, because this has a far-reaching consequences.
Yes, sir.
Maybe a very small matter for this, but it will have some far-reaching. Can you get Mr. S.K. Talukdar? Ask him. So that I ask him to be present so that we can
Yes.
hear this matter on some other day.
Otherwise, the power, your lordship, to frame bylaws is under section 9 of the act.
Final authority, so far as such titles are concerned, as the statute says, is the general body and not the register of cooperative. Because it's- Because if you see these bylaws, this act, kindly see this act that more particularly section 9,
Lordship.
9.3,
Lordship. 9-2.
9.3.
Bylaws of the society cannot supersede.
No, 9.3. Section 9.3.
Yes, the bylaws may contain such matters as decided by the General Assembly and shall be specific and confined only to the matters provided to you. However, the bylaws of a society shall in no case supersede the provision of the act.
So overall, the act will take care.
Act will take care.
It is only what is given out there in Schedule B,
Yes.
which will be within the bylaws.
Which will be within the bylaw.
Now, the authority, all resolutions so passed has to have the approval of the register.
That is what I have been instructed.
Kindly come to paragraph
I-
20 of the
They have to
judgment.
be
Para
approved by
20 of the judgment.
the Thalapam judge.
Yes,
Yes.
that judgment.
Yes, sir.
The societies are of course subject to the control of the statutory authorities like the register, joint register, or the government, etc. But it cannot be said that the state exercises any direct or indirect control over the affairs of the society, which is deep and all pervasive. The supervisory or the general regulations under the statute under the year which are body corporate does not render activities of the body so regulated as subject to such control of the state so as to bring it within the meaning of the state or instrumentality of the state. The above principle has been approved in SS Rana versus Register of Cooperative Society. In that case, this court was dealing with the benefit against the Register Society. Yeah. Mr. Talukdar, this is a very important question which is involved. Is as to whether a cooperative society would be a public authority. Because this will have a lot of ramifications. Yes, those cooperative societies which we see giving the what is that? Food grains and all. I think may be different, but we are here concerned with a cooperative bank, which is also a cooperative society. Would it come within the public? Because there are various other elements also of discharging public functions. Although in this judgment, they have referred to one judgment in the case of R.R. Rana versus Register of Cooperative Society, wherein it has been held that it would not be a state within the meaning of Article 12. But would that judgment apply to a case where it is a bank discharging public functions? Because there are many other judgments wherein it is being held. Now, in the BCCI judgment, it has been held that it would be a public authority. It will be a public authority. But that is a society completely controlled by them. And it is just registered under the 1860 Act, where the control is far less compared to the Cooperative Societies Act, where even there is a certain controls that any resolution so passed, you have to file it. So in that backdrop, can we say that the Apex Bank in this question is not a public authority? What he is asking for is trivial. It becomes very trivial, taking into account that these are various other aspects. He's asking for some bolero thing. And in fact, that person would not be now interested, taking into account that 13 years have passed by. He may not be interested. But the issue remains that so that is it. Ah. No, that is why very important is here the Supreme Court, in this case, Kalapam Azuenzo, dealt with the cooperative society in R.S. Rana and held that it is not a state within the meaning of Article 12. It is not known what cooperative society we are concerned in R.S. Rana. But here is a cooperative bank. Although this is a cooperative bank where he has passed that order.
This is also a cooperative bank.
No, in this case also.
It was a cooperative bank.
That was a cooperative bank, it was passed this order. But would the judge further development of law, because the law has further developed with this Subhas Agarwal or whatever, the law has developed. And now it becomes very less compared to not to grant. Now here the distinction has been drawn as regards a cooperative society with a company. Now, if you see the Companies Act, although there are those provisions, but those provisions are subservient to the Memorandum of Articles and Associations, because the Articles and Associations hold prominence. Therefore, you see, unless the Articles of Association say in this manner, same like in a partnership, when it says, unless the partnership deed says, they will be otherwise regulated by this. But here, if you see Rule 9.3, Section 9.3, the bylaws have been made subservient to the Act. The Act has a prominence. Now, the power which has been exercised by you under 41, 40, 39 by operation of law, although they may have some various controls as regards the board, they can do many things, but there is certain control over the board also. So if the control is there, can you say that it is not a public authority? Maybe it may be not a public authority in the case of these food grains and all. But can you say that it won't apply in respect to cooperative banks where they are discharging public function? That's another important aspect. Here in paragraph 19, the Supreme Court relies upon Federal Bank versus Hagar Thomas and held that merely because Reserve Bank of India lays down the banking policy in the interest of the banking system or in the interest of monetary stability or so and so, the Banking Regulation Act does not mean that the private company carrying on the business or commercial activity of banking discharge any public function or public duty. These are all regulatory measures applicable to those carrying on commercial activities in the state bank. If we are to believe this, we have to take this on the face value. You can't file a petition against the State Bank of India. You can't file a petition against the HDFC Bank.
Perhaps
Really?
the Bank of India and HDFC Bank could be on a different footing, Your Lordship, because their ownership and
Why?
because HDFC is almost completely privately owned, Your Lordship. The State Bank of India is a bank where the government has a majority stake, Your Lordship. So its pervasive control is anyways with the government. So from that angle also, I think it will be a state within the meaning of Article 32. So perhaps it should not be a proper comparison comparing State Bank of India to HDFC or other
Okay,
cooperative
let us take ICICI Bank, HDFC Bank.
same. Perhaps State Bank of India would be on a different footing, Your Lordship, but HDFC, ICICI, they would perhaps not be within the meaning of state or public
So
authority.
they would not be a state.
Perhaps not, Your Lordship.
But what do you take about those judgments of the Supreme Court wherein it says when they exercise public
In-
functions?
We are dealing with the scope of public authority within the meaning of the RTI Act. They may be state, Your Lordship, when somebody is
No, if you
License-
see, because here the judgment, you see after right to information, kindly see paragraph 34. The RTI Act therefore deals with bodies which are owned, controlled, or substantially financed directly or indirectly by funds provided by the appropriate government, and also non-government organizations substantially financed directly or indirectly by funds provided by the appropriate government in the event of which they fall within the ambit of so and so. As already pointed out, a body, institution, or organization which is neither state within the
Yes.
meaning of or instrumentalities may still answer the definition of public authority under so and so.
Yes.
So it may not be a
may
state,
not be a
then also it can be.
Yes. Your Lordship. So, by a plain reading of this judgment, Your Lordship, since we are only governed by the provisions of the Act, no doubt, Your Lordship, the government, register exercising powers under the government, has powers to oversee and supervise the functioning of the societies, has powers in some cases to even supersede some decisions taken by the court. But 29(4) specifically says that the ultimate power, Your Lordship, regarding the functioning of the society is with the general body, Your Lordship. So once the ultimate power, because after all, Your Lordship, a cooperative society is under Schedule 9A of the Constitution. Constitution has been amended, Your Lordship, to encourage the cooperative movement. Now, the government might have some powers of supervision, Your Lordship, but the ultimate control, Your Lordship, over the society lies with the general body and its members, Your Lordship. So once the members are not public, members are private members, the body is a private body, Your Lordship, only governed by the Act, Your Lordship, incorporation governed by the Act. Perhaps it will not be a public authority as far as the RTI Act is concerned. Though in appropriate cases, it might fulfill the definition of state for the purpose of filing a writ petition under 32 or 220. I've just been informed that in SS Rana also it was a cooperative bank.
Hmm?
In the SS Rana judgment, also it was a cooperative bank which was they were Supreme Court. The facts were the Supreme Court was dealing with a cooperative bank.
Now, what has happened to the applicant?
Your
Have we
Lordship,
made him a party?
Initially, what had happened was that this petition had once been dismissed for default earlier. Then we restored it. So during the restoration process, we were directed to make a paper application to give notice to the applicant. That was
Who was
done.
appearing earlier?
I think he had not entered appearance earlier also, but paper publication was complete, and we had filed an affidavit in that regard, but he has not entered it.
Anyways, heard Mr. K.P. Pathak, the learned counsel, appearing on behalf of the petitioner. The respondent, who was the applicant, seeking information under the Right to Information Act 2005, is not represented in spite of the paper publication. Taking into account the above, this court taking into account the above, and further to that, there being a very pertinent question which arises for consideration as to whether a cooperative society registered under the provisions of the Cooperative Societies Act 1949 and subsequently continued under the Assam Cooperative Societies Act 2007 would be a public authority within the meaning of Section 2H of the Right to Information Act 2005 has a reason for consideration. Under such circumstances, this court has requested Mr. S.K. Talukdar, the learned counsel, standing counsel of the Corporation Department, to assist this court so that a view from the Corporation Department can also be taken prior to passing any appropriate directions in the instant issue. For be taken for deciding the pivotal issue involved. To list the matter when you also have a look at Subhas Agarwal, how it is being taken. Well, no, this is the whole matter. September. It's a matter on 12th September for further consideration.
Right.
You take this. Give him the citation.
Yes.
Yes, Mr. Sharma, your matter.
May please your lord. My lord, this office not dated 24/8, lordship. This record of IoT case number 66 of 1995 has not been received, lordship. Office not dated 24/8/23, lord.
Mr. Sharma, you first tell me what is your case. Let us see whether we require all the records. First of all, there is a problem. You had, as I could see from preliminary, you were the applicants. Were you the applicants
Lordship,
who, after the death of the father,
Uh.
exercised the right under 23 or 25
lord,
of the Assam Temporarily Settled Area Tenancy Act? That was given.
Lord.
Appeal was filed
lord,
by them
them, lord.
before
Maharaj,
the Board of Revenue.
Lord.
What was the decision in the appeal?
Lordship, it was remanded back, lordship, before the learned ADC, lord.
Then
Lord.
what happened?
Learned ADC took the evidence of both the parties, lordship. And thereafter, lordship, learned ADC, lordship, found that there is no infirmity. And accordingly, that order which was passed earlier,
Was held in your favor.
lordship,
Then again they filed an appeal.
lordship, they have preferred the appeal, lordship.
Then what happened?
Then that was set aside, lordship. That order which was passed by the learned ADC, lordship, it was set aside, lord.
Now show me that. Which order? Order dated
Order dated, lordship, that is page 35, lordship, 11/5/2007.
Huh?
11/5/2007, lordship.
is 35.
Lord,
35. কি করলে?
This is-
40 টা আরম্ভ করতে তো। বুঝলে না? কি হলো? Who has marked? Very good. Yes, this is a judgment passed on 11/5/2007.
lordship,
Okay, now what is the case? How the court has dealt with?
lordship, here is.
So this is the first order you are challenging before this court.
Lordship,
How many orders? You have challenged 3 orders.
3 orders, lord,
Is this the one of the orders?
lordship.
This is the order of
Order of Assam Board of Revenue, lordship,
11/5/2007.
lordship.
No. Okay. Then what does it say?
Lordship, here, lordship,
The
This-
admitted fact that the original pattadar of the land in question was moved. The year Okay, then,
Lordship, your Lordship,
then you
Yes.
file a review.
Lordship, then I have filed a review, Lordship. And review, it was disposed of
Review of
On-
the-
16/6/2000.
So review dismissed.
Lordship,
So you have challenged this also.
Lordship,
Review of 16/6/2009.
Lord.
Review. Then, hey, yes, then,
Lordship, against this order, Lordship, I have approached the Commissioner of the Court.
this review, what happened thereafter? After this, another judgment. Oh, this is the review.
Review,
Okay.
Lordship, this is a type copy and original.
Then what else has happened? So you are challenging these two orders.
All the three orders, Lordship.
What are the three orders?
Three orders originally passed by the Assam Board of Revenue,
So that has, which was remanded back.
Lordship, remanded back.
So that has already spent its force. There's
Lord.
nothing out there. We are concerned with number 2 and number 3.
Number 2 and
So first order is 11.5 and the second is 16.8, 16.6. Those are the two orders.
Lordship.
So, okay. Now the case which can be seen out here is that there was no evidence on record that you were personally cultivating, which is required under section 23 of the 1971 Act. This is a finding of fact. How can this court under 226 look into it?
Lordship, we are the cultivator, Lordship.
Huh?
Here we are cultivating, Lordship.
You are cultivating?
Lordship. On the said plot of land, Lordship.
How are you going to show that you are cultivating?
Lordship, subsequently, Lordship, I have submitted affidavit also, Lordship.
No, affidavit. How can this court decide that this is a fact finding and the inquiry has already happened? How can this court override that? The board is the fact finding authority. Why should this court under 226 more particularly issue a writ of certiorari? This court is not exercising an appellate jurisdiction.
Lordship, the concerned land is at Pamohi, Lordship. Whereas this Bahar Ali is staying at Gandhibasti, Lordship. And from Gandhibasti to Pamohi, Lordship, it is about 30 to 35 kilometers, Lordship.
Why it has changed its location? It's not 30 to 35. No, it's not so far.
Approximately 30 to 35 kilometers, Lord. Lordship, now, this as it is a cultivable land, Lordship, the person who has the land, he ought to be within the jurisdiction of 10 miles, Lord. Now, in the instant case, Lordship, this Bahar Ali, he was a government employee drawing the pension, Lordship, and he is staying at Gandhibasti, Lord. And as such, he was not a cultivator.
Hmm.
And also, Lordship, my father's name is Prabhat Rangpi, Lord.
Huh?
Prabhat Rangpi, Lord.
Ah.
Prabhat Rangpi, he stood with a Khotian, Lord. That Khotian number 54.
And how did you get it?
Lordship, when Prabhat Rangpi expired, Lordship,
Ah.
then we have applied for ownership. We have applied for a mutation, Lordship.
Hmm.
And accordingly, Lordship, this mutation was granted. Hereafter, Lordship, we have applied for ownership right, Lordship.
Hmm.
And,
Hey,
in the-
ekon liokon. 1971 ekon.
and in the ownership right, Lordship, this, after following the due process of law, Lordship, and the order was passed. This order was passed, and accordingly, Lordship, I was directed.
No, tell me, Mr. Sharma, whether there is a requirement of you being cultivating. You have to personally cultivate. You have to personally cultivate. That is
Lordship,
the reason why it has been rejected. You see the paragraph out here in the judgment of 11/5/2007. Kindly come to paragraph number. This at page 38. relevant evidence on record.
Relevant evidence of record
Ah.
show that the land in question is not a cultivable land.
Hmm.
At the time of filing the petition by the respondent number 2 and 3 for ownership right. And on the other hand, and also it is seen from the said evidence that the respondent number 2 and 3 are not cultivating tenants at the time of filing the state petition for ownership right. As per provision of section 23 of the Assam Temporary Settlement
Volume
Act 1971, any occupancy tenant personally cultivating the land of his tenancy are entitled for acquisition of ownership right of the said land. Since the present respondent number 2 and 3 are not occupancy tenant personally cultivating over the said land in question under the appellant, and as such, according to the provisions of the aforesaid section 23, they are not entitled for acquisition of ownership right over the said land in question under the present appellant. Lordship, when we have produced the evidence before the learned ADC Lordship,
Hmm.
Lordship, at that time we have clearly mentioned that we are cultivating the land. Lordship, we are cultivating the land, Lordship.
Hmm.
And on the other hand, Lordship, this Bahar Ali also submitted the affidavit.
Hmm.
He has clearly stated
Hmm.
that he is a retired person drawing the pension, Lordship. And Lordship, this subsequently we have submitted the affidavit, Lordship, and affidavit with the affidavit, Lordship, we have annexed the photograph also, Lordship. How we are cultivating, Lordship, those photographs are annexed, Lordship.
You should file a suit. How can this court decide all these things? From these facts, what is wrong with the facts? Here the court has come to a finding, the final authority on facts, that you are not a personally cultivating, which is required under section 23. That is the mandate of law. You have to be personally cultivate. Now you say that you have been personally cultivating the land, isn't it?
Lordship.
Now how can this court say that that is wrong? Tell me.
Lordship,
If you want this court to visit out there, then it's a different thing.
Lordship, I have submitted the affidavit. My evidence was taken, Lordship, before the
In that
ADC.
affidavit, have you been cross-examined?
Lordship, it was cross-examined, Lordship,
By?
by their advocate, Lord.
Then where is the cross-examination? Let's see.
Lordship, that copy,
Yes, Mr. Sharma.
that copy,
Huh? Records have been called for. Yes, did you cross-examine him? You see, the finding of fact arrived at by the learned tribunal is the relevant evidence on record shows that the land in question is not cultivable land. At the time of filing of the petition by the respondent number 2 and 3, that is an evidence that is on the basis of a ascertainment of facts for ownership right. And on the other hand, it is also seen from the said evidence that respondent number 2 and 3 are not cultivating tenant at the time of filing of the said petition for ownership right. This is a finding of fact. Is it perverse? It's perverse. Huh? If you are saying it's perverse, then we set aside. Finding of fact arrived at under what circumstances? Let's see record. You have filed affidavit of what? Showing photograph.
Lordship, this
What is the basis of the court finding, coming to an opinion that it is not a cultivable land?
Lordship,
Huh?
for clarification of this lordship, this diatic case number 66 of 95 is necessary, Lord.
Now this person concerned is physically handicapped. This is Annexure C. What is this type of land?
Pau Peti land.
Pau. And Nova. Nova. No. So, Mr. Sharma,
Lordship.
the senior Sharma, what do you say as regards whether he is personally cultivating or not? What is the basis on which the court has come to a finding? How much is the land? 4 bighas. You are not personally cultivating.
I am cultivating, Lord. And the plot of land is by the side of my plot of land, Lord. By the side of my residence, Lord.
So you are going to cultivate on that land.
I am cultivating each year, Lord. Each year cultivating. And Lordship, I have submitted an affidavit also. In that affidavit, Lordship, I
Where
have even annexed some
affidavit on a position
affidavit,
by
Lordship, I
issuance.
have submitted
Huh?
23 Lordship. 23 that additional affidavit I have submitted, Lordship. In that affidavit, I have annexed some photographs, Lordship.
Which, where, what you have from, photograph. So this one,
Lordship.
what you are cultivating, all are full of assets.
Lordship,
What you are cultivating?
how petty, Lordship.
Okay, on the side of it is all assets, and this is how do we know that these lands belong there? This might be somewhere near Dhemaji. They
Lordship,
have
this,
such big land. Are you saying
this-
that page
this
45
petition-
of your application or 112 of the document?
That
Are you
petitioner
saying
is
that this is the plot of land of 4 acres?
4 bighas, Lord.
Have you seen it? Can this be the land in Pamui?
Lordship,
Cannot be, Mr. Sharma. This land which you are saying at Pamui at page 45 of his additional affidavit cannot be this land on top of it. You don't get such type land.
Lordship, it is
I am not here. I am not sitting out here. Yeah, I know what is the real position of the land. Huh? He's not in possession now. Is he in possession? We are saying about the 4 acres of land, and you are saying that there is this thing on top of your land. Are you saying that there is a high tension wire?
Lordship,
Now, Mr. Sharma, are you telling me that you have a high tension wire over your land? These land at page 40 of your additional affidavit, there is no high tension wire. And what is this at page 45? There is a high tension wire.
in this photograph, that petitioner
Please
himself,
see at page 44. The land is different from that land at page 45.
Lordship, this
Are you
photograph,
saying this 4 acres of land is this land?
Lordship,
It can't be so.
Lordship, part
You
by part,
in Guwahati, in the Pamuhi area, you don't get leased land. On the other hand, you see at page 41, these are all bounded. There's a boundary wall, so everywhere, and it is full of water hazard.
Lordship, these photographs are taken part by part, Lord.
Part by part, are you saying that this land at page 45 is a land? This is a land somewhere near Sipazar. This
Lord-
can't be a land in Pamuhi.
This petitioner, he himself,
Not
This
there on top.
Lordship, it is his residence, Lordship. It is
On top.
his-
Top, are you saying those grains, the food grain, the paddy fields is his residence at
Lordship,
page 45?
page 45,
Yes.
that is after harvesting,
Are you saying that this is that plot of land which on
It
the
is-
vicinity on the
it is-
horizon out there, you see, can you say this to be a 4 acres of land? Are you saying that there is a, what you call the a high tension wire line on top of your land? Yes, we should put these people to ask the CID to make an inquiry against these type of and as to whether the photographs are false. Who has certified it? Also, and make this inquiry. Come, who is it? Who has certified it? To be true? What is his name? Advocate? Mr. Sharma?
Lordship,
Whose
Might be-
signature
might
it
be-
is?
might
Who has
be-
certified?
might be S. Sunita Lord.
Yes, some Sunita.
Lord.
Yes. Sunita Sharma. He'll inquire, make an inquiry. Because here is a different plot of land, there is a different plot of land. Page 41 has all around water assets and the others is this. A very serious thing which we have done. You see the paddy field which is there at page 39. It's not a field, it's an area. This is bounded on all 4 sides with bamboo. And all around there is water assets. On the other hand, see the other photographs at page 42. There's a hill on the left-hand side. And then at page 43, hill on the left-hand side, and then page 45. See, there's a high tension wire. And there's no hill anywhere.
Lordship, this hillside road is there, Lord.
Are you aware that there is a road which is now connecting the airport from that road?
Lord.
Are you aware?
But one
The
time-
Pamohi area.
Oh, here it is.
Then what evidence did you give before the authorities that you were personally cultivating?
Lordship, at that time, Lordship, these petitioners have given the written evidence, Lordship. And as per instruction, Lordship, it was cross-examined by them, Lord.
Where is it?
Lordship, this document, Lordship, it is regarding cross-examination, it is not with me, Lord. Cross-examination, it is not.
Because
with
here
me.
it categorically says that the relevant evidence on record shows that the land in question is not cultivable land at the time of filing of the petition by the respondent number 2 and 3. What is the basis on which it was formed, that opinion was formed? And what do you say about section 21, that it cannot be given to a physically handicapped?
Lordship, this,
There is a certificate to that effect.
Lordship, that certificate, Lordship, it was issued by a health and medical officer, Lord. And health and medical officer is not a competent person. Here,
Very well, but there is a direction by this court, by Justice Buzarbur, and pursuant to that, the deputy commissioner has done anything?
Lordship, in the meantime, expired.
Or Bahar Ali died? Hmm? And then what happened? This matter? No, not here. There's another matter where there is an order being passed out here. I could see from the record. Is it this case, 49? Oh, in 49 only. There was a direction for this. In this case only.
Lordship. 892.
Oh, yeah, in this case. But then it was remanded back again. Where's the writ appeals order? No, but unless you show something that there is perversity and he is not the competent authority, but there is a certificate being given that he is physically handicapped, what else is required?
Lordship, this certificate,
Does it say under the act that that has to be a certificate issued by some authority? Tell me.
Lordship, the Honorable Single Judge clearly stated that that certificate which is issued is not the correct Lordship.
But that judgment no longer remains.
Lordship,
Does that judgment remain?
not remain
Yeah.
as expired Lord.
That judgment has already gone because of the remand. Because the judgment was set aside. You have the division bench judgment. Yes. So that has been set aside. Unless you show something, there is nothing.
Lordship,
And
No.
he's a handicap. We have to hold it.
now Lordship, as he expired Lordship, that claim cannot be sustained Lordship.
Huh?
As he expired Lordship, it was remanded back for re-examination of Bahar Ali Lordship. In the meantime, Bahar Ali expired Lordship. As he expired,
So the order by which we are in an appeal. We are not in appeal. We are against a writ against an order being passed by the Board of Revenue.
Lord.
The Board of Revenue, when he passed the order, he was taking into account the order which was passed by the ADC.
Lord.
Now the ADC had given you the right on the basis of without taking into account the proviso to section 21. So I'm only concerned as to whether he has done it rightly or not. I'm not concerned with anything else.
Lordship, is regarding this Lordship, that priority case number 66 of 1995 is very much essential Lordship. Because there it will speak regarding whether I was cross-examined or not, Lord.
Now tell me
Because-
only one thing.
because
No,
of-
Mr. Sharma, the senior Sharma. If that period is gone, whether a res judicata would apply if his application is rejected because of the physical then. Now the ownership has changed. Obviously, res judicata would not apply. If that is the reason why he is physically handicapped, that is what. Mr. Sharma, the appeal repetition is I'll pass the order. However, I will say that it couldn't have been given because he was physically handicapped. Now that period is over, then I leave it to whatever you think. That is the only way out. The instant application has been filed by the petitioner. A main order to who is paying for the revenue? Yes. The instant application has been filed by the petitioners in WPC number 1916/2016.
Yes.
On the ground that in the certified copy so issued to the petitioner, the names of the petitioners have not been reflected in the certified copy. It is also the case of the petitioner that the names of the counsel who were representing the petitioner as can be seen in the original order copy. As can be seen in the original order dated 9/8/2023 have also not reflected in the certified copy. This court, upon hearing the learned counsel for the parties, it is Kakar Namdi was MSA for the Mr. A. Bhattacharjee for the SC Revenue, Mr. N. Mustafi for the Deputy Commissioner. Deputy Commissioner where?
Corpata.
Corporate. Government advocate for the Deputy Commissioner. It is seen from the order dated 9/8/2023 that this court had granted liberty to the petitioners in 3 writ petitions, that is in WPC number 2142/2007, WPC number 1916/2016, and WPC number 772/2017 to file applications within 30 days from the said order. Seeking allotment/settlement of the land as per the extent land policy of 2019 of the government of Assam. The not furnishing of a certified copy without the names of the petitioners in the said certified copy would create unnecessary complications, as it cannot be asserted by the state official, by the revenue officials as to whether the petitioners in WPC number 1, whether the petitioners whether the applicants where the petitioners in WPC number 1916 of 2016 this court further observes that the names of the counsels representing the petitioners as mentioned in the order, as is reflected in the original order, is also a part of the said order. And as such, the entire certified copy, and as such, while uploading the order, it was also necessary on the part of the registry to upload the names of the counsels representing the petition. Under such circumstances, this court disposes of the instant interlocutory application with the following directions. Number one, the registry shall issue a certified copy of the order dated 9/8/2023 thereby indicating in the said thereby containing the names of each of the petitioners in WPC number 1916 of 2016, as well as also WPC number as well as also WPC number 2142 of 2007 and WPC number 772 of 2017. Further to that, the registry is also number two. The registry is also directed to upload the entire order sheet of the order dated 9/8/2023, wherein the names of the counsels representing the petitioners should also be mentioned as this court further taking into account number three. This court further taking into account that it is on account of non-furnishing of a certified copy to all the petitioners containing the names of the petitioners. The petitioners have not been able to file the appropriate application as directed. Further grants another 30 days from today for filing the appropriate application. I think that is enough.
Yes.
With the above, the instant petition. Itu Before
At number 2021. Part
dismissed. Yes, you are prepared now. You have not challenged the fine or refund. They are seeking not remission, they are seeking the refund. So they have paid the amount.
Yes.
Have you paid the amount?
Well.
So this document at page 50 of the secondary petition has been challenged.
Yes, yes. Yes, sir. Tell us. In PR, page number 19, madam.
Mr. Counsel, this time I am excusing you, but next time I will have a lot of problems what you have done. That day I still remember you said that you wanted to change it, make necessary corrections. I did not allow you. Did I allow you? Why
Yep.
did you make the change in the repetition? Why did you make a change?
Sir, I have taken permission.
No, I never allowed you.
Sir.
Then why did you make this change?
Still, I have not heard it properly. Madam, sorry.
No, it's a very serious thing. You have done it. Why have you changed it? I never said that you, at the time of passing the order, you said that, can I
Yes.
change it? I said, no, nothing doing. Then,
Actually, I have wrongly heard. My lord. I have asked for
Mr. Sharma, you were there very much.
I was there, my lord.
Did I give the permission?
Your lordship has not given it directly permission. I think, and he presumed that your lordship has given the consent.
No, he had
And
presumed it, but you were there. Did I give the permission? He had asked, I didn't give it.
Yes.
Then why was this changed?
He is misgiving here.
Huh?
Misunderstanding. Yes, misunderstanding.
There is no misunderstanding of all these things. Next time, hey, black book or lekhi dekho. Next time, if you do all these things, I'm going to take it. The very serious thing which you have done. When this court, after you have asked that, then there's also this court had not granted you. Then why have you done that?
Sorry, madam.
Now, what do you want? Tell me.
Madam, we want to develop the land after cutting the trees, and then we have to remove some earth from that land.
And what are you going to do with the earth?
We have to export the earth from that land. So for that purpose, we are ready to give TP transit Salan.
No, so you remove this earth to which place?
Anybody, if anybody want to purchase it,
So if you sell it, then it is a minor mineral.
minor,
Then you are liable to
Yes.
pay.
liable to pay. Then we will have to take transit first matter.
So then the question of refund, I am not going to pass an order of refund now. If anything has to be removed, you take the permission, inform them, and then you will adjust it. And
Yes.
after adjustment, anything remains, you refund.
My lord.
That is the only Both the writ petitions are taken up for disposal by this common order. The petitioners herein are joint owners of a plot of land measuring 13 bighas, 3 kathas, 9.8516 lechas, covered by DAG number 1253 of Patta number 744, situated at Gotanagar under Jalukbari Moja. The said plot of land was used by the predecessor in interest of the petitioners for nursery and planted some trees. After the death of the predecessor in interest on 26/6/2011, the petitioner planned to develop the plot of land, and for that purpose, in the year 2015, they applied for a permit, planning permit, before the Guwahati Municipal Development Authority. Full stop. The application the planning permit was issued by the Guwahati Municipal Corporation. And the petitioner was requested to contact the planning branch, Guwahati Municipal Corporation, for further processing of the proposal for issuance of a building permit. This document was issued by the town planner, Guwahati Metropolitan Development Authority, on 2/6/2017. Thereupon, the petitioner filed an application before the Guwahati Metropolitan Development Authority for boundary wall permission. And in that regard, a receipt was issued on 24/5/2017. It is not known as to whether the building permission was accorded to the petitioner. The petitioner further, upon receiving the planning permit from the Guwahati Municipal Corporation, applied before the Forest Department for felling of trees, earth cutting, and dressing the plot of land. On the basis of this application filed by the petitioner, the Divisional Forest Officer, Kamrup East Division, Bokista, issued a communication dated 6/8/2016 to the Circle Officer of the Guwahati Revenue Circle for joint verification of the said plot of land. Thereupon, a joint verification was carried out on 15/11/2016. The joint verification report can be seen from Annexure 6, Roman 6, to the writ petition. A perusal of the said joint verification report shows that the land in question is a patta land belonging to the petitioner bounded by the boundaries mentioned therein. In column number 7 of the said joint verification report, it was mentioned that the land is situated at a distance of 120 meters from Gotanagar Reserve Forest. The said document was signed by the range officer, survey and demarcation range, as well as by the circle officer, Guwahati Revenue Circle. The report of the joint verification was forwarded to the Divisional Forest Officer, East Kamrup, by the communication dated 1/12/2016 by the Circle Officer, Guwahati Revenue Circle. In the said communication, it was mentioned that in the joint verification conducted on 15/11/2016 in respect of felling of trees over the land of the petitioner, it was found that there were 67 numbers of raw wood trees. It was further mentioned that the land was a Miadi Patta land, and as per the record about 30 years ago, and the land is situated at a distance of 120 meters from the reserve forest. Subsequent thereto, there is another communication issued on 9/12/2016 by the Circle Officer, Guwahati Revenue Circle, to the Divisional Forest Officer, Kamrup. Wherein it was informed that at the time of investigation, at the time of verification, it was found that about 20,000 CUM, not CM, CUM.
Cubic.
CUM land would be cut and removed. And as such, it was informed that the land can be removed or transferred and considered as per the departmental procedure. Pursuant thereto, on 25/5/2017, the Divisional Forest Officer, Kamrup East Division, informed the Additional Principal Chief Conservator of Forests, Research and Education about the list of trees of Gotanagar area as submitted by the Range Officer, Guwahati Range, for favor of the said authorities' information. Subsequent thereto, the additional PCCF, Research, Education and Working Plans, Assam, issued a communication on 1/9/2017. Wherein it was mentioned that a survey was carried out at Gotanagar area, bracket, Dag number 1253, Patta number 744, comma, bracket, on 21st and 22nd of February 2017, using different global position system, bracket, DGPS, bracket close, by the GIS team of the Forest Department and MTRON along with the undersigned, along with the additional PCCF, comma, officials of Kamrup East Division and the owner of the surveyed area. It was observed that the land in question had substantial forest cover and was originally unreserved, what is this, USF? Unsurveyed forest, bracket USF. It was further mentioned that as per the order of the Supreme Court dated 12/12/1996, in the case of T.N. Godavaran versus Union of India and others, the area under question would be deemed to be a forest irrespective of the ownership. And therefore, no part of the area can be diverted without prior application of the forest conduct application under the Forest Conservation Act 1980. Subsequent thereto, on 18/11/2021, an application was subsequent thereto, on 18/11/2021, the Divisional Forest Officer, Kamrup East Division, had issued a communication to the Circle Officer, Honapur Revenue Circle, informed the later that an application was received from the petitioner regarding permission for earth cutting and transportation of earth from the PP land, from his land, and as such a joint verification along with forest officials would be necessary to ascertain the status of the land in question and fix a convenient date. It further reveals that on 28/2/2022, the Circle Officer, Guwahati Revenue Circle, informed the Divisional Forest Officer, Kamrup East Division, that a joint verification to ascertain the status of the land covered by Dag number 1253 of KP Patta number 744 of village Gotanagar under Jalukbari Moja in respect to the application received from the petitioner has been fixed on 30/3/2022 at 11:30 a.m. The record further showed that out of the 13 bighas of land, the petitioners have also taken a permission to transfer 10 bighas of land to one MS Top Bill Infrastructure, which was issued by the Office of the Deputy Commissioner, Assam Land and Revenue Branch on 2/7/2022. It is also relevant to take note of that in the meantime, as informed by the learned counsel for both the parties, the land of 10 bighas have been transferred by the petitioner to MS Top Build Infrastructure. Full stop. Therefore, the land in question for the purpose of the present dispute is only 3 bighas. Is only 3 bighas, 3 kathas, 9.8516 lechas. That's all. The petitioners, from the above facts narrated, it transpires that the grievance of the petitioner is that the petitioner wants to clear the land measuring 3 bighas, 3 kathas, 8.8 lessers by cutting the unnecessary earth as well as by removing the trees in order to develop the land. However, the respondent forest department have not issued the necessary permissions for which the petitioners are not in a position to develop the land. It is under such circumstances that WPC number 282/2023 was filed by the petitioners. It reveals from the records that this court, by an order dated 21/2023, issued notice. Full stop. The record reveals that another writ petition was filed. Full stop. In the meantime, no. This court further finds it relevant to take note of that that pursuant thereto, the petitioner was imposed a penalty of rupees 2,69,052 by the office of the Divisional Forest Officer, Kamrup East Division, which the petitioner have duly paid. In the earlier writ petition, the petitioner did not challenge the communication dated 1/9/2017, which was, however, challenged by the petitioner in the second writ petition, which have been registered and numbered as WPC number 2998/2023. This court have duly heard the learned counsels for the parties. Mr. Your name?
G. Pathak.
G. Pathak. Mr. G. Pathak, the learned counsel appearing on behalf of the petitioner, had submitted that the petitioner only anxiety is that they want to develop the land measuring 3 bighas, 3 katha, 8 point so and so lechas, 8.5 lechas, by cutting the unnecessary earth as well as removing the trees The petitioner has no objection to hand over the trees to the forest department. You have no objection?
No.
To hand over the trees to the forest department. If the forest department wants to take those trees. It is also being submitted that although the amount of rupees 2,69,082 amount there have been already paid as regards the penalty, it has also been submitted that there will be a requirement for cutting of the hill, which may result in unnecessary result in excess soil, which cannot be used for the purpose of developing the land. And the same may require to be either removed from the land. So this court have also heard the learned counsel appearing on behalf of the forest department, Mr. D. Gogoi, who submitted that the objection of the forest department to the felling of the trees is on account of, what is that? Assam? In terms with the provisions of the Assam Control of Felling and Removal of Trees from Non-Forest Lands Rules 2002. So as per clause 4.1 of rule 4.1, these, you have this. Kindly come to page 89. These trees do not require permission. These specific trees do not require permission. Yes, but permission for felling of tree for non-forest area, including registered plantations, shall be granted following the provision as prescribed by so-and-so issued prior approval of the forest department. Permission for felling of for self-consumption shall normally be granted within 30 days from the date of receipt of the application, complete on respect by the so-and-so. In such cases, no transit pass shall be issued for applicant. Permission for felling of trees in other cases shall normally be granted within 60 days from a year completed on register. In case of registered plantation, felling trees, permission shall normally be granted. Now, these are not registered plantations. So it will come within the ambit of, if these are the trees and as per 4.1, no permission is required. But as regards the other trees, they have to take the permission which you have to grant without fail by 30 days. And are you going to remove those trees, Mr. Sharma?
Firewood is not required. You have to cut the jungle.
It is, no, some trees are not required for permission. Have a look. Arm is not required.
Yes.
Jamun is not required. Kothal is not required. Eucalyptus is not required. Agar is not required. Poplar is not. All species of home ground bamboo is not required. Letico is not required. Ponial is not required. Madhuriam is not required.
There is a one jackfruit kathal is there and might be one mango is there.
So these are not permission
No
required.
permission.
What else other trees are there?
Other trees, that are firewood trees, those are jungle trees, normally not used, raw wood trees, 67 number. Okati, which I mean Okati tree. If you're interested, they can verify it.
And they are willing to give you the back the trees if you want. You want it? Taking into account the submission of Mr. D. Gogoi, this court finds it relevant to take note of the rules of 2002 bill of the rules of 2002. From a perusal of Rule 4, it transpires that there are various species of trees which do not require any permission for felling. Those have been enumerated in Rule 4.1. Rule 5 stipulates permission for felling of trees full stop. In terms with Rule 5.2, if the permission for felling of trees is for self-consumption, the same shall normally be granted within 30 days from the date of receipt of the application, complete in all respects by the divisional forest officer. In such cases, no transit pass shall be issued against the operated trees. However, permission for felling of trees in other cases shall normally be granted within 60 days from the date of receipt of the application, completed in all respects by the divisional forest officer. In terms with Rule 5.3, in case of registered plantation, felling permission shall normally be granted within 30 days. Rule 7 stipulates confiscation of trees in violation of the rules of the guidelines. Mr. G. Pathak, the learned counsel appearing on behalf of the petitioner, submits that in the land of the petitioners, there are a few mango trees and jackfruit trees, apart from other trees which can only be used as firewood. In such circumstances, in the opinion of this court, no felling permission is required. However, if there are certain trees which do not come within the ambit of Rule 4.1, the petitioner would require to obtain the necessary permission. This court also finds it relevant to again to note the submission of the learned counsel for the petitioner that as regards the other trees, the petitioner has no objection if the forest department takes those trees. Taking into account the above, this court directs the divisional forest officer East Range, na? Kamrup East Division, to make a verification within 15 days from the date of receipt of a certified copy of the instant order as to whether there are any trees other than which have been mentioned in Rule 4.1. In the land of the petitioner. If there is any trees other than those mentioned, upon making such verification, if it is found that there are other trees which are outside the scope of Rule 4.1, the divisional forest officer Kamrup East Division is directed to grant the permission to the petitioner for the purpose of felling the same, so that thereupon the forest officials, the forest department of the government of Assam is directed to, should I direct or give liberty? No, as regards taking those trees, liberty, no, because you may not like the tools. It's given the liberty, shall grant the permission to the winner, and the forest department thereupon is given the liberty to take those trees to confiscate those trees. Huh? Should we go for confiscate? No. To now, however, liberty is given to the divisional forest officer, East Range, is Kamrup mein, taking into account the no objection on the part of the petitioner that the forest department may take into custody the trees, the felled trees, to take into custody the felled trees if found necessary, if found useful, if so necessary. Next. Further to that, as regards the permission to cut the land, next. The other issue which arises is as to whether the forest department could restrain the respondents and the petitioners to cut to remove the extra art, to cut the hill. The next issue which arises is as to whether the forest officials, forest department of the government of Assam has any authority to grant permission for earth cutting and dressing of the land of the petitioner. Good stop. Nothing could be shown before this court that the forest department has any authority as regards the cutting of the earth cutting of the land belonging to the petitioners. Full stop. This court had also heard Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the revenue, who also had submitted that the revenue department has no objection as regards the earth cutting from the private land of the petitioners. Full stop. Taking into account the above, this court permits the petitioner to go ahead with the earth cutting in respect to the said land. Full stop. It is, however, observed that if the excess earth is removed, then in that regard, removed and not consumed by the petitioner, the same would entail imposition of royalty by the forest department, as it is a minor mineral. And as such, in that circumstances, the necessary verification would be required. Full stop. It is made clear that a petitioner at the time of removal of the earth, extra earth, shall take necessary permission from the forest department, who shall accord subject to the payment of royalty. This court further takes note of that an amount of rupees 2,69,000 so and so have been imposed as penalty upon the petitioner, in spite of the fact that there has been no removal of the earth cutting had taken place. Under such circumstances, the penalty so imposed ought not to have been imposed by the respondent authorities. Be that as it may, taking into account that the amount that there would be certain removal of the earth, the forest department is directed to take note of, is directed that after granting the necessary permission for removal of the earth, adjust the amount of royalty so paid, the amount of rupees so and so paid against the royalty, against adjust the amount so already taken as penalty against the royalty to be paid, and refund whatever is left. With the above, both the repetition.
Both the dark to be mentioned.
Huh?
Both the land dark to be mentioned. Otherwise,
I mentioned the dark number.
only 1 year lot has mentioned that regarding 3 bigas, but 30 bigas that is there is a 12 dark number, pattern number 12 and dark number 30.
Where is it mentioned in your petition?
In the second petition, your lord.
Second petition is different land.
No, both dark. It's 2 land. One first edition, 1 dark. Second edition, 1 dark.
Huh?
Yes. And see.
Where is it?
Yes, page 1, page 24.
Page
24. 24. Your lordship mentioned first edition dark number. This is second edition dark.
Here you have not sold any land.
That is
Not
12.
sold.
Not
Huh?
sold. Not sold. Not
Here
sold.
we have not. sold.
And it is joined. There is also joined the verification. Page your lordship. Finally, see page 33. Page 33.
No. This is a different plot of land.
No, the same adjacent. my lord.
Adjacent plan.
Adjacent. This one. This
This
one.
So you have not challenged 19/2017 in the earlier petition.
No, both petitions there is there. Both petitions.
Show me where you have challenged.
In pair, I have mentioned.
No.
Paper-
Where have you challenged 19/2017? In the earlier petition?
Yes, lord. Page 19. Paragraph 11.
No.
Yes.
Where is that 19/2017 letter?
That is paragraph 11, Your Lordship. There is 19 stating entirely their survey was carried out Bhutanov area.
Mr. Sharma, kindly see page 50 of that second writ petition.
Yes, Lordship.
What is the DAG number?
It is tag number 744. 1253. 1253.
Does it say anything about 12 and 30?
It is 1230 in subsequently in this petition, they joint verification on the both the tags.
I'm not concerned. This document is not there for that.
Yes, yes.
Then why you're saying all these things? But where is the mention that you want to art cutting for permission for that?
Yes.
Show me that. Where is it?
There is application is there, ma'am.
Where?
In tag number in that first petition, Your Lordship will find.
So you have paid 1,269 and 1,267. How much amount have you paid?
262 total amount.
Total amount for what? Both the DAGs?
Both the tags, both the tags.
No, it is nothing to that. Have you cut our earth?
And we have dumped it
in
when they registered the case. They have seen and we have dumping it, they put the point.
Oh, where is the joint verification for 12 bigas? Nothing is there.
Yes, 12 because
Have you asked for permission for the purpose of this 12 bigas in your writ petition?
They have done so that thing. They have get the land one company.
that is told.
That is not them. One Hariwal.
No, we have not told it. We have only Rishi Gupta. No. Tribunal.
This joint verification is not there on record. No, it is not a part of the. Then why should I say anything about 12 bigas? No, the 12 kathas I am not mentioning anything. You have not mentioned anything about the 12 thing. Where have you mentioned in your writ petition about the 12?
Kindly see in the page 33. Joint verification report, both tag mentioned.
Where?
Page
Page
33.
of?
Up by 2998. Both tag mentioned. And Your Lordship kindly page 32 is vernacular. There is joint verification both.
And how much land is remaining? You have not sold.
We have sold in the another 10 bigas.
So you have already,
10 bigas only.
no, you have already cut the earth
And dump it.
in both the cases.
No. In the 30 tag number 30, second portion, 2998.
Show me where is it? In your writ petition you have stated that.
That is in there.
Where have you mentioned that you have cut the duck?
Page number 36 there.
I am saying where in the petition you have mentioned it,
Permit.
that you have cut the baya and kept it.
Yes. Paragraph number 12, Your Lordship.
Of?
Page number 12, page number 10
Of?
2998.
Yes.
That the petitioner begs submit that your patata has entrusted one person Kushal Rajvanshi to work over the developing landscape area. Tag number 30, patata number 12, art cutting work started, made their land feasible for construction, but suddenly the forest district range office as art cutting instrument laborer registered a case against Kushal Rajvanshi, being case number 2 and fine imposed to.
So the imposition is in respect to this land, not that land.
Now, this land,
not that land.
not that.
So then the imposition is right. Why you have done it without
We
any
have
imposition?
cut it and dump it. We're not removing it.
No, 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 no. Why is the question of not only that I'm not removing it? How did you cut the air trees? How did you cut the trees without
Actually,
permission?
we have not cut trees. There are some tree lands there.
Where have you said?
Some tree is there.
No, are you saying that there is no tree? So then in that regard, in Patta number 12, there shall not be any cutting of trees. Don't cut any trees. I'll pass the order to them. No cutting of trees, no felling of trees in Patta number 12.
That should be verified by them.
No, no cutting of trees. Then the imposition is right.
Yeah.
No cutting of trees. You have, why did you cut without permission?
It is a firewood trees, but jungle cleared.
Then the imposition is rightly done. Because your petitions, whoever has drafted it, they don't know how to draft it, draft the petition properly. How have you done? See the praise what you have done it, Mr. Sharma.
Keep an evidence of the
Hey, is
order.
this the petitions in which you have done it? Please the matter before any other event. I'm cancelling this order. Please the matter before any other event. Let anybody else decide. Not going to pass. No. This is not a case where I'm going to. Please the matter.
Item 9.
Yes, Mr. Goyal, what is this matter?
Matter relates to whether the, my lord,
Oh, the
chairman of-
technical member.
my lord, whether the chairman can,
Technical member alone can decide it.
my lord, whether the chairman can say technical member to decide in this manner. This is a two issue, my lord. I have prepared my
Where
Roger Matthews, my
not required to so many
Your
judges.
lordship may kindly come to first, my lord, statements of my lord,
Railway Claims Tribunal.
tribunal, your lordship, statements of object. and
Yes,
re-
Mr. Goswami, you are appearing for whom? Register? Okay. Now he has challenged the act. What has he challenged out here?
I have challenged the note letter that your lordship will find at page 46 and subsequent order part thereafter.
Directing the employer to constitute a bench for judicial adjudication of the non-judicial constitute to educate inside the constitution and if sufficient cause constitute a member of the. Yes, let us see the railway claims
My lord.
tribunal.
My lord,
Yes.
I start your lordship, then my lord.
Yes, where is it?
Page your lord, I have quoted your lordship,
Yes, yes. Composition.
composition.
The
I would like
the
to- my-
tribunal shall consist of a chairman, 4 vice chairmen, and such numbers of judicial members as the central of a union member, subject to other provisions. Then shall consist of 1 judicial member and 1 technical.
Railway claim.
So we are into 4.2.
My lord, so far, subject to the other provisions of this act, a bench shall consist one judicial member and one technical man. Close, my lord, subsection 4 says, my lord, notwithstanding anything contained in foregoing provision of this section, it shall be competent for the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, power, and authority of the claims tribunal in respect of such classes of cases or such matters pertaining to such classes of cases as the chairman may by general or special order specify.
provided that if at any stage of hearing of any such case or matter, it appears to the chairman or such member that the case or matter is of such a nature that it ought to be heard by a bench consisting of 2 members, the case or matter may be transferred by the chairman, or as the case may be referred to him for transfer to such bench as the chairman may deem fit. I would like to, my lord, place section 5 also. Qualifications for appointment as chairman, vice chairman, and other men. A person shall not be qualified for appointment as the chairman unless he is or has been a judge of a high court, or for at least 2 years held the office of vice chairman. A person shall not be qualified for appointment of vice chairman unless he is or has been or is qualified to be a judge of high court. My lord, your lordship may skip over. Thereafter, clause D, has for at least 5 years held the post under the railway administration, carrying a scale of pay which is not less than that of a joint secretary to the government of India, and has adequate knowledge of rules and procedures and experience in claims and commercial matters relating to railways, has for a period of not less than 3 members held the office of judicial member or technical member. Your lordship may speak over, my lord. A person shall not be qualified for appointment judicial member unless this is for judicial member. He is or has been is qualified to be a judge of high court, has been a member of Indian legal service, and has held the office in grade 1 of that service for at least 3 years, has for judicial
5-4.
my lord. 4 is for
We are concerned with the technical member.
my
The technical member, as you can seen that he has at least 3 years, for at least 3 years held a post under the railway administration, carrying a scale of pay which is not less than the joint secretary, and has adequate knowledge about the rules. Adequate knowledge about the rules is subjective. We can't go into that. We are only on the question of objective. The objective satisfaction is that he has been qualified for appointment as a technical unless he has 3 years, at least 3 years held the post in the railway administration, which is not less than that of a
my
government.
absolutely.
That's all.
So the question came up before Honorable Apex Court, my lord, whether, my lord, in deciding the matter, whether a technical member can decide the issue or not. That the Honorable Apex Court Roger Matthew at paragraph 158 to my lord 161, after my lord taking note of the scheme of the act, my lord came to the conclusion that, my lord, if the technical member is adjudicating the matter, it will amount to, my lord, the encroachment of, my lord, member in the judicial field. That, my lord, observations are required to be placed before.
Where?
My lord, page 158 of
Not necessary. You have quoted it.
Roger Matthew. Yes, my lord, I have quoted.
You have quoted it in your petition. Yes, others may go. Others may go.
May I read, my lord, page 58, page 24?
Yes.
In Madras Bar Association versus Union of Supra, 5-judge bench of this court reiterated the urgent need to monitor the pressure or influence of the executive on the members of the tribunal. It was asserted that any tribunal which sought to replace High Court must be no less independent or judicious in its composition. It was also clarified that the members of the tribunal replace.
Roger Matthews was a case under the railways.
No, my not raised.
Then how are you bringing the Roger
My lord,
Matthews?
the issue whether my technical member can, my lord, alone, it may be railway or, my lord, administrative CAT, your lord.
No, Roger Matthews was a case for what?
My lord,
Show me
it is
that
kept-
now. Now give me your comparison.
Gujarat High Court in respect of railway says judicial member can alone take. That judgment I have
Technical member can't.
can't. Gujarat High Court. And the matter went to Supreme Court. The Supreme Court only issued notice, no stay. But
Why you are bringing Kusum Ignotes?
my lord, it is in respect of, my lord, central legislation. If one High Court is given one decision in respect of central legislation, it is applicable to the country because of that.
They are concerned with Madras Bar Association. Roger Matthews,
Roger Matthews.
2020,
It start from 260, your lordship.
260.
My lord, and I am taking your lordship to relevant paragraph that your lordship will find at page 408. No?
Wait, 260. Hmm. So time. Oh, done. Appointment of the qualification. What is this tribunal we are referring to here?
Here, Railway Claims Tribunal.
No, here.
Here, my lord, it is, my lord, page. It is, my lord, appellate tribunal, smuggler and foreign exchange manipulator.
Huh?
Under smugglers and foreign, that para 160. My
Very
lord, it is
good.
composite appellate tribunal under the
Starts from where? Page?
page 1408. Your lord, may kindly come.
No. Yeah. This is for himself. 1, 2, 3. Investment is the of maintenance, clarity and tribunal.
It is in respect to appointment of members in tribunal, all tribunals, including railway claims.
Doctor. So this is for all tribunals.
All tribunals.
Okay, now come to the
Including
page.
hereafter, my
Let
lord,
us see 158.
page 408, my lord.
Yes.
May I read your lord?
Mhm.
In Madras Bar Association versus Union of India, a 5-judge bench of this court reiterated the urgent need to monitor the pressure and or influence of the executive on the members of the tribunal. It was asserted that any tribunal which sought to replace the High Court must be no less independent or judicious in its composition. It was also clarified that the members of the tribunal replacing any court, including the High Court, must possess expertise in law and shall have appropriate legal experience. Even though Parliament can transfer jurisdiction from the traditional courts to any other analogous tribunal, the tribunal must be manned by members having qualifications equivalent that of the court from which adjudicatory function is transferred. Hence, any adjudication transferred to a technical or non-judicial member is a clear act of dilution and an encroachment upon the independence of judiciary. It was further ruled by this court that even though the legislature has the powers to recognize or prescribe qualification for members of tribunals, it is open for this court to exercise judicial review of the prescribed standard. If the adjudicatory standards are adversely affected, the decision of this court reads as follows. My lord, then the paragraph you are quoted. Then your lord may kindly come to para 159, 411, my lord. We concur with the above, which reiterates the consistent view taken by this court in a number of cases. It is also a well-established principle followed throughout in various other jurisdictions as well, that when Parliament decides to diverse the traditional court of their jurisdiction and transfer the list to some other analogous court or tribunal, the qualification and acumen of the members in such tribunal must be commensurate with that of court from which the adjudicatory function is transferred. Adjudication of dispute, which was originally vested in judges of court, if done by technical or non-judicial member, is clearly a dilution and encroachment on judicial domain. With great respect, Parliament cannot diverse judicial function upon technical member, devoid of either the adjudicatory experience or legal knowledge. It is necessary to notice para 160, my lord. Notice few other changes brought about by the new rules. Firstly, most tribunals were earlier headed by judicial members, with the exception of some tribunals like the debt recovery tribunals. Presiding officers were retired judges either of the Supreme Court or High Court. Under the present formulation of rules, the central government has widened eligibility by making persons who otherwise have no judicial or legal experience, but if they are otherwise ability, integrity, and standing and having special knowledge of and professional experience of certain specialized subjects, which in the opinion of the central government is useful, eligible for being appointed as presiding officer. Further, others we are qualified to be Supreme Court or High Court judges can also be head tribunal. A perusal of Article 124, Sub 3 and 217(2) of the Constitution that it specifies only the very minimum prerequisites for appointment as a judge of the Constitutional Court. Instead, the predominant portion of the consideration for appointment to this court or to the High Court is uncodified and is based on a holistic consideration of the practice, legal acumen, expertise, and character of the advocate. The effect of new criteria would be to make every second advocate eligible, in fact, vastly diluting the qualifications for appointment. The characteristics necessary of such people are also vague, which resultantly increases executive discretion. It thus affects both judicial independence as well as capability and competency of these tribunals. The power discretion vested to specify qualifications and decide who should man the tribunal has to be exercised keeping in view the larger public interest, and they must be just, fair, reasonable, and not vague or imprecise. At this juncture, it must also be reiterated that equality can only be amongst equals, and that it would be impermissible to treat unequals equally on the basis of undefined contours of uniformity. A tribunal to have the character of a quasi-judicial body and a legitimate replacement of court must essentially possess a dominant judicial character to their members or presiding members. It was observed in so that it is a fundamental prerequisite for transferring adjudicatory functions from courts to tribunals that the latter must possesses the same capacity and independence as the former, and that the members as well as the presiding officer of tribunals must have significant judicial training and legal experience. Further, knowledge, training, and experience of members of presiding officer of the tribunal must mirror, as far as possible, that of the court which it seeks to substitute. Illustratively, the composition of appellate tribunal under the so Act delineating this incongruity is reproduced below for reference. The chairman of the appellate shall be a person who is or has been qualified to be judge of a Supreme Court or a judge of High Court. The member of appellate shall be a person not below the rank of joint secretary to the government of India. So, further dispensation of justice requires that the adjudicating institution command respect with populace. Analogous situations created by allowing High Court judges to be appointed to the position occupied earlier by Supreme Court judges affect the presumption. The same stature of the people manning an institution lend credibility and of
All are understood. But the section remains as it is.
my God.
The
Validity.
power which has been given as per the section, the power is given. Even there is no mention of judicial or technical member. Now, can this court hold that particular provision to be bad?
It can be read down if you
How
are.
can you read down this provision unless you challenge the provision? Because the whatever may be, if you see this paragraph number 158, the last part,
Right.
it is open for this court to exercise judicial or prescribed standards. Judicial prescribed standards means you have to challenge the provision,
But
isn't it, Mr. Sharma?
my lord,
Without challenging this section 4, how can this court exercise? If the law remains like this, how can this court exercise the power?
one thing, my lord, other thing which, my lord, that will also may interfere. In the appointment, my lord, appointing my lord member technical to decide the matter on the basis of division bench judgment, in my humble submission, my lord, it amounts to, my lord, giving direction to the member to decide the issue in a particular manner. In that count itself, my lord, that appointment, that impugned letter is bad in law, because that letter says, my lord, to decide the issue on the basis of division bench judgment given by
Show me that.
my lord. Page, my lord, Annexure 1, page 46, your lordship.
What does the Gujarat High Court say?
My lord, that I have annexed with this petition, my lord. In fact, the findings is
The powers
based
of
on that, my lord, your lordship may kindly come to Gujarat High Court judgment at page 77.
first appeal is admitted and taken up for it.
And I'm taking your lordship page 80, your lord. It says even it is required, my lord, then judicial member will check. A single.
Now, you see, we have heard the learned advocates for the parties and perused the materials on the issue involved in question has all been decided by the apex court in Amulya Chandra Kolita. Given that, wherein it has been observed that every bench of the tribunal must consist of a judicial member and an administrative member. Therefore, the administrator alone could have been heard and decided
Chandra
that so and so.
My lord, that's
Even in the coordinate bench of this court in deciding had special level have to uphold the orders, even assuming that all the powers of the tribunal could be exercised by a single member, can only be by a judicial member of the tribunal and not any other member. For the sake of the decision, since the question of law and interpretation is even the single member of the tribunal cannot hear and decide the OA, and subsequently, since he was an administrative member, he has no jurisdiction by the for this turn. So the division bench decision was with the central in a year, the principle laid down in the state judgment cannot be made, it can be made. That is, I think,
against that
with
review
due
was
respect to the learned judge, too far-fetched.
my lord. Review was preferred, my lord. That was dismissed. Against that SLP was filed, my lord. And on pending notice, I think. Page 85, I have.
Now show me that what has been
Page
directed.
46, your lordship.
Huh?
Page 46 of my writ petition.
Yes, with reference to your mail dated so and so million, dated of the subject, I am directed to inform your honor, please to empower Lina so and so by nominating her to hear and decide on matters pertaining to terminal charges as so and so on the basis of the judgment of the on in view of the large one time. So what is wrong?
On the basis of the judgment of double bench comprising of
That is,
honorable
you see, the English has not been properly used. It is said that by applying the law has been laid down by the division bench.
Lord, in my humble submission, that also, my lord, it can be distinguishable. It is the matter. We can't say, my lord, whether this division bench you decide in this.
No, they have said on the basis of the judgment of the division bench
That also,
comprising
my
of
lord,
the then chairman and the honorable
lord,
on the above
whether
subject.
that judgment is
On terminal charges, there is some decision of the some division bench. It's called
my lord, not this court. That I appeared in, my lord, I appeared. No. My lord, Justice Rumi Fukan, it was given, my lord. I appeared for the.
no, anyway, whatever may be.
And
there is a judgment of the division bench or whatever may be that has been to see as per what has been done is for administrative exigency, looking into account that look here that why should we have two members deciding? We can have only one member decide.
Lord, in that case, my lord, I will apprise, my lord. Despite, my lord, I have not challenged the validity of subsection 4. I think, well, on the basis of that judgment, I will try to some that your lordship will clarify that because the bench consists of judicial and technical members.
Therefore, you have to, in view of the judgment of the Supreme Court in that judgment, Roger Matthews, you have to challenge it. Unless that provision remains in the statute books, this court cannot say that the technical member had no jurisdiction. Okay.
My lord, can it be taken up, my lord, on 12th?
Right,
12th September.
today is what?
My lord?
What is today? Today is 29, 31st.
31st, I am not. Tomorrow I am going out.
Okay, tomorrow at 2 o'clock.
My lord, tomorrow I am going out of.
You know, we dismiss the matter now. You find you want to take the benefit of Roger Matthews, you assail it by
I understand, my lord, what you are coming from. On 7th, you are also 7th of September.
7 point.
My lord? 7th, I will come back on 6th, my lord. I said,
Oh, people have waited till 5 o'clock. I spent unnecessary 1 hour for
my
one
lord,
matter.
through your lord. I also tried to, my lord, assist your lordship, but I could not, my lord. What is coming from your lordship, my lord, that I have to examine. And one thing more, your lordship.
No, whatever may be,
One thing more, my lord.
whether there is or not, the law prescribes you can. They have not mentioned judicial layer. Like that day I was taking up a matter of permanent local 22C, 22B, 22B of the Legal Service Authorities Act stipulates what is the quorum. It has to have one chairman, one vice, one member technical, and one member judicial. Without that, you can't. So under such circumstances, that is the mandate.
One decision, if your lordship, in case of Mahabal Ram, that was placed before this honorable court in the first round of litigation, my lord, where honorable apex court says if the request is made by the party to refer the matter to division bench, request should be exceeded. In the present case, request was made without assigning money. It was.
That is a case where you need to challenge it in the proper forum.
I have before the tribunal, my.
Against that, you file appeal before this court under an MFA. That is another question. You can't exercise 226 for that. That will be a jurisdiction under, at best, far-fetched, a jurisdiction under 227.
23 appellate provisions there.
That is what. How can this
One
court
thing more,
exercise that?
I understand, my lord, what.
Like Justice Pardiwala had exercised under 23. Yes, Mr. Waiting till 5 o'clock till
7th, your lordship. In that day, whatever, if it is required to be withdrawn, I will withdraw.
no, the only thing is that you see, for that to bring Roger Matthews, you have to challenge it. Without challenging it, you can't. Eh? That is it. If he wants, he can very well. You can very well bring that notion of that is the notion. Now you have a constitution bench judgment, but you, without challenging it, till the provision remains in the statute book.
Absolutely.
Because that would be for this court holding that although that was not a case of railway tribunal, this court still holding this act to be bad, which this court would
That's
not
why we are learning, my lord, day by day. On 7th, my lord,
list the matter on 7.
deep law.